Yeah, good afternoon, everyone. This is Hemant Mehta here. Uh, I welcome you all to this WRC meeting, first meeting of this year of IBC study group. So yeah, please come. So, friends, I think let us introduce each other and then we will start sharing the practical experience so far because we have not been in a position to meet since since more than a year, I think. Because of this, yeah. It is online only where, it is not possible to interact with each other on the way in which we meet personally and interact with each other. So it's good. And I think you can introduce yourself and you can say that, right now, in what capacity you are right now practicing the law, whether in the lawyer capacity or whatever capacity or, so that we can start the proceeding of the meeting. Fine? So, yeah. No, sir, I am comfortable here. Yeah. I am comfortable here, no issue. So, fine. So, I have with me Kirav Trivedi ji, who is also one of the leader in this meeting. Basically, this meeting is organized not only, this is an interactive forum, basically. Study group means you have to interact with each other. And then you have to share your practical experience, and whenever you have queries you can ask the people of the within the forum, and you can get many opinions. Instead of getting one or two opinions from the friends, you can get many opinions from each and everyone. Fine. So you can introduce yourself and you can just tell me what exactly you are
So I'm Ashish Vyas. Ashish Vyas.
Yeah.
I'm an insolvency professional also. Like, there are two CRPs running. I'm liquidator in two companies. This is answer to the question what level I'm at.
Atul Jain is speaking. That is what I am just I can see from the screen, but I can't hear you, Atul ji. शुड वी कॉल? अरे वहां से आवाज नहीं आ रहा है, हम लोग जो बोल रहे हैं।
नहीं बोल रहा हूँ सर मैं।
अच्छा ओके, उसमें वो स्क्रीन आ रहा था। हाँ ठीक है, आएंगे वो देवांग जी आएंगे। ठीक,
जैन साहब यहाँ आना चाहिए था।
मैं बाहर हूँ सर, जरा
ओके फाइन।
बाहर बैठा हूँ।
हाँ जैन ओके हाँ, you are enjoying the full at resort, good.
Best of both worlds.
नहीं ऐसे स्क्रीन रखो, हमको भी लगता है कि we are also in resort from here.
Yes.
And
Yeah.
Next time we will have it there.
Yeah. We will organize some RRC at that place.
अपना ही रिसोर्ट है, कोई वादा नहीं है।
Yeah. Welcome, sir. Welcome.
Fine.
So we have with us Ketan Sayaji, Vikasa chairman, and
Secretary Shweta Jain, madam. We are fortunate to have them.
It's a mere coincidence. Attending one student seminar, whole day seminar we have kept on various e-portal. Like we had session on MCA, in the morning we had on GST, now it is on income tax. Chintan Masani is addressing. And after this there is a TDS session. So we have kept a students training program. That was the direction of government, that you hold a program for portals.
Acha. How to
use the actual portal. And Praveen sir was there out, so I said I want to learn this. बाकी मुझे ABCD आती नहीं है, IBC का full form भी नहीं आता है।
नहीं good.
Last 5 years only the subject has developed.
हाँ, but आप लोग तो master हो गए हो।
नहीं वो तो क्या है?
Yeah, we welcome Shweta ji, secretary WRC.
Hi everyone.
Yeah, hi. So it's our pleasure to have both the office bearer with us. And
Rudesh bhai is there, regional council member.
Hello, Rudesh bhai is a regional council member. Welcome, sir. So few words from Shweta ji, Ketan Saya ji, and Rudesh bhai if possible.
Ajay, please. Sure.
I think I will move it.
No, वैसे भी वो ले,
No problem.
आगे ले लेंगे ना वो।
एक चेयर आगे।
तो हम लोग क्या WRC में ये सब शेयर खेलते रहते हैं सब।
लेकिन हम लोग IBC में नहीं खेलते।
Yeah. So good afternoon, everyone. And I think it's the first study group meeting.
No. Okay.
First meeting is
Yeah, first physical meeting.
So thanks to all of you. You have taken a lead. So and I'm sure this year also will go as last year's जैसे पहले से होता आ रहा है, इस बार भी काफी अच्छा चलेगा. 2-3 रिक्वेस्ट थी जो मेरी फोन पे बात हुई थी, प्रवीण जी से भी बात हुई थी, हेमंत सर से भी बात हुई थी. So उसके ऊपर we are working on it. Let's see how positively we can do that to add some non-chartered accountant also into this group. So let's see how we can take it further, and very soon probably we'll come out with the good news and solution with that. So my best wishes to all of you. Thank you so much.
Thank you, Shweta ji.
Actually, this was very good, to look the real requirement of the group.
Yeah.
See, this is orchestra thing. IBC is like orchestra. We are given a company to manage. Only chartered accountant cannot play a very significant role. We require a lawyer also, company secretary also, and at times we require engineers also.
Yes.
But engineers we don't require to work on IBC, but the lawyers and company secretary we require them to work on the IBC, and without which it will be an incomplete group.
Correct.
The second main problem is that in Bombay there might be only 100 IPs. So they are all groups. From chartered accountant group there might be 25-30 only. Out of that 10-15 are there who are like full time only IP. Others are doing multiple roles. Sometimes they are doing income tax, sometimes they are doing audit, sometimes they are doing insolvency.
So the same actually I have discussed with VP sir also.
Yes.
So they said that okay, you can invite them as a special invitee per session wise. That's not an issue because membership के लिए
We agree, na? If you are allowed and there is a participating here, then our problem is solved.
Yeah, so we can
The
invite
main
them.
difficulty if we keep it only for IBC CA student or a CA members, then we will not get more than 15-20. So then what happens? The people who are coming also they lose interest. जाने दो ना 15 जन होते हैं क्या जाने का? That is the approach.
True.
And doing it virtual as well as live is again a big advantage.
Yeah,
Because a lot of people who are not in Mumbai are able to join, so that's a
Yes.
big advantage.
So that also was discussing that how we can go ahead because other than Mumbai, otherwise people will not be able to join.
They are interested, but they are not somehow physically not in a position to attend.
And other than Bombay, this study group is not. I think Bombay and Ahmedabad only 2 centers. This all over India, this study group.
Study group.
Ahmedabad is one of the important centers. Bombay is another important center. If it is Bombay, then Pune, Ahmedabad, Nasik, Nagpur also we can encourage
So
them.
for that, what we can do is we can talk to our branches.
Yes.
So if they can start something at their own, and if they can invite
They
some.
are
Yeah, we'll merge it, of course.
They can
So-
join virtually.
So because individually they know better कि वहाँ पर practicing में कौन IP में है, कौन किस में है. So we can take them,
We
take
have
help
the
from
list of
them.
all Maharashtra from our IBVA. We
Okay.
can tell to them.
That's great. That's great. In that
Because
case,
in a city like
We can tell to all.
okay.
small city like Satara, there might be 1 or 2 IPs only, who are practicing. Now it is very difficult for them to join meeting and.
Place like Satara, they can come to Pune easily.
Yeah.
Like 1.5 घंटे में पुणे पहुंच जाते हैं.
हाँ.
If there it is virtual, then there is no need.
So they can.
If you plan such group at Pune, for example, a city like
Pune, but
Pune,
it will not be.
नहीं होएगा. पुणे में 5
लोग नहीं
रहेंगे तो क्या करें?
10-15 है गिन के मतलब there are very few.
और वो भी
As a finger trick.
सब प्रोफेशन के CA के 5 ही होंगे.
हाँ.
Yes sir.
One more session which today we have discussed with Naneji is for the students also, for the CA students who want to make career in future for the IBC related. We should have some student program also where we can give them what type of trainings they can get it in IBC, chartered accountant who are practicing.
In fact,
We
I
are
was about
happy
tell
to
you.
do that.
In
We
fact,
are
I was
happy
about
to do
tell you
that. Yes.
that you
If the
people
student wants
design,
like that.
you people design one whole day program and
Yes.
tell us, like beginning from what is IBC to everything, like what attestation we do, what actually you work, and what I suggest that then in there also you can for these articles you can tell, like we have a process of giving them on a training basis also, like, one form, if in my firm somebody is interested in IBC, I can send 6 months for 6 months on a segment basis to province's firm. So that people get that type of opportunities.
Now actually one article student from Mulund has come to my office. He from the day was I want IBC. I want IBC.
So that type of students are coming.
तो आप एक
now-
फुल डे प्रोग्राम डिजाइन करिए.
हाँ.
आपके ही ग्रुप के स्पीकर हो तो हमें भी ज्यादा
वो बेस्ट है
मिल जाएंगे सर इधर से.
उस केस में ये ग्रुप का अल्टीमेट बेनिफिट दिखेगा आपने.
As we discuss,
practical oriented for the students.
अगस्त जुलाई का हमने शेड्यूल सारा स्टूडेंट एक्टिविटी का करके रखा है. अगस्त महीने में आप डेट डिसाइड करिए.
एनी टाइम आप बोलोगे तो हमारे तो क्या इधर ही 8-10 स्पीकर है, सब स्पीकर ही है.
So the whole day time we can plan 4 or 5 sessions and 4 to 5 speakers. So 1 or 2 days in fact if we want intensive training.
4 स्पीकर रख के 1.5 घंटा देते हैं उनको.
Yes.
1.5 hour to 2 hours के 4 स्पीकर हो तो आप डिसाइड करिए.
वो प्रोग्राम कर सकते हैं.
Yes.
तो मे बी
Just
पोस्ट
came
योर टुडेज
today only
मीटिंग
in my mind.
पोस्ट योर टुडेज मीटिंग आप उसका एक स्ट्रक्चर करके अगर आप दे देते हैं.
Chairs मंगा लो.
यहाँ पे चाहिए.
Okay, as I heard that since 2-3 years ये IBC का ग्रुप बहुत एक्टिव है. So और opportunities भी आ रही है तो it's better for chartered accountant also they want to know about it more. So if they study in a group system, of course it is
Our
going to be
difficulty
beneficial.
this was a totally new subject. And everybody is handling a different type of case. So we all wanted to learn. The law itself is evolving today.
Yes.
Every year we say that law is evolving, and then the best way to learn is to come here and learn practically, and then teach also. So that when the students ask and the members ask most questions, we try to learn.
Okay, so I'll not take much time. If you both can add something, so then.
Nothing. I think my subject is being covered as I said initially only that I don't know even ABC, but yes, I also like a student. I also want to learn. This is one of the area which is upcoming area, and absolutely everybody has been seeing the downside in the SMPs. So I think for newer members also, please design some program. This group can design some program like what we are saying for student. Also, you all can think of some simple publication, some handbook or some publication which WRC can publish, so that if somebody wants to start a career, एक handbook होगा उसके पास क्या करना है कहाँ से कहाँ जाना है. And also some of you, if you can become mentor. Earlier I told to Praveen sir that also, like आप में से जिसके पास actual काम है या नया काम शुरू होने वाला है, if you all can become mentor and you take on assignment basis either student or new members, those who want to enter this practice. So for example, you are starting with one assignment and you have there are 5-6 people who want to learn the actual work. You take it them on assignment basis, you mutually decide whatever payment terms or whatever way you all want to do. तो उनके लिए एक प्रैक्टिकल सीखना हो जाएगा, आपके लिए एक क्वालिफाइड आदमी मिलेगा जो अच्छी तरह से काम कर पाएगा. So it will be a win-win for all of you.
There are few restrictions. See, they can learn the subject, but they cannot practice unless they are 10 years old. That is a big.
But there is
is a
Graduate insolvency program is there, but that is 2 years.
Yeah, but at least कोई 5-6 साल का experience chartered accountant है, and if they want to work with you, 5 years भी काम किया तो best है ना.
We are always welcoming. Initially, in the first year, when you used to call somebody for interview, उसको बोलते थे IBC profile देना तो भाग ही जाता था. वो मेरे को GST audit और taxation तो IBC मत दो.
So that's why I'm saying that in my students, because I am also a speaker in some of the faculty programs. So in that we found, and as we discussed today, we find कि students के भी दिमाग में आना चाहिए कि IBC है क्या. And again, there is a 10 marks question in the exam. They will also know the practical how to deal with IBC matters.
So that's why so much all of you
discussion.
for being active
Yeah.
and holding such meeting. We are very very grateful to all of you. Over to you, Rudesh bhai.
No, nothing much. Thank you, Ketan sir, and thank you, Shweta ma'am. I think definitely since insolvency and bankruptcy is one of the most emerging field, and for a lot of new members, I think who look for, though they are of course allowed to practice after 10 years only, but a lot of would want to, I'm sure, work. So the way we would design for students, for young, the newly qualified chartered accountants, for them something we can do, I think that's going to be a best one. So August, as sir rightly said, we can plan up a one-day session and we look forward for this. Thank you.
Thank you. You all can carry on.
That exam classes what you conduct, there also you can have 3-4 lectures.
Yes.
Yes.
Even
सेपरेट प्रोग्राम रखने की जरूरत नहीं. कंपनी लॉ में जो पेपर है तो कंपनी लॉ के साथ साथ तुम 3-4 सेशन रख दो. इंट्रोडक्शन टू आईबीसी एंड whatever it is.
Correct.
Perfect.
And main is के other branches also you inform that you can join WRC studies group here virtually. So then what happen, anywhere from Bombay or anywhere from Maharashtra, Goa region or out of the region also people will join.
wherever you have a student programs, you can call us.
In fact, this was a pioneer group in India. This was possibly the first group, maybe provided by Hemant and everyone, started at Trivedi. And then some crowd was gathered. When we had sufficient strength, then the group was called in over here.
Okay.
And from the very first day, there was limitation of 100 people, but they were more willing to join. Because at that point of time, you had even people from other professions, maybe other institutes, who had the permission to join at this particular course. And after the study group was formed over here, then a number of groups were formed at different parts of India. So there have been pioneering efforts right from the beginning for this group. Second important point is, maybe it's not only insolvency and bankruptcy code. There are many other related areas of maybe our professions and other professions also, which are associated with insolvency and bankruptcy code. For example, transaction audit, forensic audit, how maybe statutory audit or accounting has to be done for companies under insolvency and bankruptcy code. Maybe a lot of assistance is required even as consultants, especially in taxation areas or company law areas or maybe for listed companies, SEBI related areas where chartered accountants could be of very great help. So it is not only practicing as an insolvency professional, but the areas which are around the companies under insolvency and bankruptcy code, also that have great future for all the professions. Information utility, that is collecting information of all the companies and individuals of India. That is something which can go on for years and years. And except for chartered accountants, no one is tuned all over anywhere in India to provide that sort of information to government. So if someone has a basic understanding of the code, they could be great assistance not only for the profession but also for the nation.
Great.
We'll take it forward.
Yes.
Yeah, from the IBC committee, the study group, I am thankful to office bearer of WRC for giving their valuable time and and the first meeting of this IBC committee, making them presence and guiding us. So thank you very much.
Thank you.
Thank
Thank you to all of you.
Thank you so much. Yeah, please be continue.
Thank you.
Thank you. Thank you.
Thank you so much.
Last year also if you have any solution कुछ भी लगे तो
Yes,
बता
yes.
देना.
Yeah, if you need any support and
Yeah, so yes.
Please come, Devang. Be seated.
Sir,
First of all, I apologize for being a bit late. It was beyond my control, so I apologize to all the members. Very unprofessional, but I apologize.
You can come forward so that one or two seats which are there still we can have a meeting. Seat for people.
Seniors first. हमें लोगों को बनना seniors जो.
No, you can. I will. Please.
today we have two topics to discuss. One is about the issues in individual insolvency, and second is the discussion paper on the professional fees for the resolution profession, CRP resolution profession. This was introduced after our meeting was fixed, but then I said now we will not change.
This is the appropriate time to discuss also. It's a nice time to discuss.
Right
when the
time,
thing is wrong.
nice or right time both to discuss the same. And here all our practicing members are here only. Nehal bhai, aa jao.
This is online also.
Yeah, this is over.
Yeah.
And welcome to the physical meeting after long, almost one meeting we had physically in between.
Last year.
Burgesh Amin was there. And I think last 2.5 years we didn't had an opportunity to have the physical meeting. I was insisting for the physical meeting because the interaction which we have at physical meeting, it cannot be compared with the virtual meeting. Okay, and I request all of you to add few more members to this group. Otherwise, sustaining will be very difficult. And then if the attendance is poor, then discussion may not be that hot or debatable. That is another thing. And I also request that this is a study group and not study circle. So here the emphasis is on our own preparation of the subject. And whatever my experience is, whatever preparation we do, whether others learn or not learn, but we learn it very well. And then there is a lot of opportunity. This is in a way a platform to learn the subject and then address outside also. And this is a golden opportunity because whatever doubts, difficulties, mistakes, clarification, all will be evened out here. And then you have a world of opportunities open for you. So please prepare any subject, come here, we are here to help you, guide you, assist you if required. And then you can start that. Whatever required for swimming, we are here to help you. And float देना है, hand पकड़ना है, सब कुछ देना वो सब करेंगे. But start somewhere. One day you have to start. So with these few words, I think all of them doesn't require any sort of introduction. They all are active in IBC. So let us start. I think we will have 1 hour 15-20 minutes for individual and 1 hour for that discussion paper. Yes, sir.
Fine.
Nearby कुछ
बोलो सर.
जो कोड है वही सर चालू करो सर. Let's start discussing.
What we internally thought over is that there is one thing that we go through the points of the code and what the personal insolvency is. But for this particular group, we found that is not much relevant because here what we should actually do is to find out what difficulties we are facing and how to address those difficulties rather than just putting, because this is available with everybody and we are into the profession. And this is not something which everybody has to brief what personal insolvency is. But what are the case laws? How do you actually go about it when you give an application? What do you do? So that is what we thought. But if the members feel they want to go through the particular provisions, we are open for that also. So we leave it on to the members.
Provisions, I don't think we require.
Or maybe if you have some queries in the provisions, we are there to address as such.
Anyone looking for going through provision? I think provision
everyone is aware of, and we can go through it. But what practical difficulty we face is what to do right from day one. First of all, even applying for PG is an issue because we find that many times, SBI as well as others there are lots of applications that come, but end of the day you find that none of them is actually going on for appointing a person. So these right from the expression of interest to the banker to the actual process. It is a challenge in itself.
Is it possible to know how many members are there online, or maybe able to communicate with them 2 ways if there are queries or something?
Yeah, we can communicate in 2 ways. Right now, also we had a talk with Atulji. So Atul Jain ji is here. So
I'm here. Devang bhai, how are you?
Yeah.
Fine.
You
Nice
keep your
to see you,
camera
sir.
on, sir. Yeah, we are feeling like we are also sitting in the resort.
Yes, sir.
So please keep your camera on. Yes.
Okay.
So Atulji, let us now discuss how many of us have have experience of individual insolvency, handling individual insolvency.
No, I have not done it, nor I intend to do.
Good.
Please.
Good, sir. Yeah.
Any other participant who is there online and who is having an experience or some queries on practical aspects? Experience, anyone can please feel free to introduce himself or herself.
I think.
Okay, at any point of time, please interrupt for queries. Rather, we will be learning from your queries because everyone is trying to work a way out in difficult situations which are coming on this. Maybe a new aspect of code, and maybe many members over here are already having experience on personal guarantors. So definitely an interactive session at this point of time at every particular section would be great. So Kirav, can we begin?
Yeah, I'd like to start right from the first process of how do you apply for a, when an expression of interest comes, what is the thought process that one has and what is the thought process the banker has. Normally, we can keep in mind that we have to work for a period of 3 months, 6 months. That's how we code. Plus, whenever we get a quote for expression of interest, we find that nowadays bankers are expecting everything from us. They expect that you have to quote for yourself, you have to quote for any other additional person you want, you have to quote for a lawyer, you have to quote for, everything, even valuers they ask you to put a quote for. And then when everything is quoted off, they found it's very, very heavy. So they again come back to us or they do not respond back. So there is in fact, putting an EOI is also sometimes a task by itself. How much to put and how do you address the situation? So that's one aspect of it. And what I found challenging is that whenever you start quoting, they start negotiations only on the IP front. The rest of the front is not discussed. But when you quote, the quote is for the full amount. So end of the day, the responsibility is for the RP to ensure that everything is gathered. At the same time, when he gives an EOI and when the negotiation starts right from day one, how to reduce is what the banker's requirement is. And that's one of the reasons I think many of the practicing members who are already doing CRP are not interested in going for PG as such. I think what I have experienced out here is that earlier on the fee structure was such wherein the bank had an experience wherein a lot of heavy expenditure is incurred on the RP and IRP. So they are taking a step back, but the step back which they are taking is impacting us more rather than anyone else, because now they want to restrict everything. They want to restrict the overall amount. They want to restrict the number of months. Irrespective of how many months it goes on, you have to do it for. We will pay you only for 6 months or we'll pay you only for 3 months. That is how the impact is. So based on their earlier experiences, they are trying to experiment on us, saying that we will be restricting you. Here also, when we go for a quote or when we ask for a requirement for EOI and when we apply for it, what is happening here is that they say that you have to quote for everything, and they expect that you need to have your own internal law firm or internal law resources who have to contribute to it. So there is nothing extra that you get, or the fee that you get is too small an amount for you to outsource it. So in fact, there are two ways of looking at it. One is that either leave it off and say, I'm not interested, I would preferably go for a bigger assignment. Second is to accept the challenge. See, after all, somewhere you have to start. And we have to also prove that we are better than maybe the others who have been charging exorbitantly. With due respect, but they have been charging exorbitantly, because of which the banks are now taking a stand that no, we do not want to pay, we want to put a restriction. Even this circular which has come over for the fee is in fact a way in which
reflection
the pressure has been coming on us only. Why don't you restrict yourself to a particular thing? Whereas the fact is that out of, if you make an analysis of the IPs in India and how many are doing it, I think 90% are the reasonable ones. Only maybe 5 or 7% are at the top level who, because of their nature of expenses, would be at a very, very expensive thing. But the banker is taking that as an example and trying to implement on all of us. So we have to find a way out. Like how I have approached is that I have taken it as a challenge. Forget the fee part. If I am allowed to do a particular exercise by myself, then how do I do or experiment it? So for legal part, the fee is not such wherein we can outsource anyone, but we can do it on our part. We can do from our end only. That is what I have observed. In fact, that is the advantage of this profession is leaving off the IP part. There are other things which comes on to you just because the financial concerns are there when you start a CRP process. Same applies for PG also. So I think we should not be scared of doing an application.
Before we go into this,
Yeah.
Let's just run through the not provisions but the process, because once you give the quotation, what I understand, and what is the role that in PG you have to do. There is a huge difference.
Yes,
when we are talking, when there is a huge difference what we do in CRP and what we do in PG. So what is our key role and what we are expected to do? Once you identify that, then we can take one at a time and understand about the fee aspect. Otherwise, talking on the fee aspect, comparing PG with CRP, it's something you are comparing apples with oranges.
Yeah, but the responsibilities in a PG is much, much higher than because here you have to give what is expected, or what the code requires is that it is the RP who has to give a report. Based on that report, the Honorable NCLT is going to give his reason whether the PG...
So you start from the zero level, suppose the EOI you file.
EOI you file.
And the bank selects the one of the, suppose there are 10 or 20 RPs who give this, then bank selects the one. Then bank appoints you
Then bank gives us a letter stating that you have been appointed. That is the process. Then we have to start getting information from them.
Information from?
From them. For example, you
From the person?
No, from the bankers. First is that normally what happens is that bankers issue notices. They wait for 3-4 months, 5 months, and then they try to find out the resolution.
They issue that.
Under IBC, they issue the notice. But what happens?
Invocation of guarantee or?
Yes, invocation. No, there is a notice, specific notice which is there in a format under IBC. They issue that notice
to PG.
To the PGs. When they issue the notice, that time nobody is there, so they do it on their own. What right from one, if you just observe how the forms are being filled up, is that they just fill up the form, they've mentioned annexes, but none of them is actually given to the PG. When you start asking information from the bankers, these are the standard documents and loan agreement, personal guarantee agreements. But when you actually apply to NCLT, you have to give a copy of those agreements. So for them, it is a normal process. For us, when we take the next step, it is very necessary for us to have the complete set of documents. And what happens, the basic part of even sending a notice, what NCLT or what the AA asks is that it is not the notice that you are sending, it is the receipt of the notice. So here what happens, if you send by speed post a notice and if you do not take the tracking details, which are available only for a period of 10 to 15 days, then you cannot track it later on. So when you approach NCLT or when you fill up the application and you give all the details, you will find that the notice is there, the proof of dispatch of notice is there, but proof of receipt by the other party is not there. So first question which NCLT asks you is show me whether he has received or not. And at that time, it becomes very difficult for you to prove because already months are over and you cannot go back to the post office department or postal department.
Sorry to interrupt, but this process, who does? RP has to do or
yes,
bank
precisely. No, RP has to do. See, right from filing the application to NCLT to the complete process of giving his report to the education.
Why RP has to do? This is not the part of our
It is not mandatory. It is not mandatory. But where is the consideration for it? Somebody else does it, then
so
you have to pay
let
for
it be done. No, because you get into a tangle by doing this.
They are not paying.
Huh?
They are not paying that.
There's an option of one-time fees and there's a recurring fees.
Every bank has their own way of working. What I'm trying to push across to the group is the think process. What is the role of the RP? Let's discuss the role of the RP in PG. What Kirav told is perfectly correct, but that is the role we eventually have jumped in. Why are we taking the risk? I am of the firm opinion that if you want to stay in this profession for a long run, this is a profession of a matured people. And being a matured people, you should not be in a hurry to grab all the things that comes your way. Even if the things doesn't come your way, you have to wait for a good opportunity to work on the transaction, whether it is PG, CRP, liquidation, voluntary liquidation, any of the processes. Then only you will survive in a long run. 2-3 transactions, everyone will get by grabbing the things. But how will you survive? Survival will come to a challenge if you start taking at a low rate, giving these free services to so-called bankers. Once we all stop giving these free services, automatically they will have to get it done through someone else. Let that person take that charge. You taking onus creates a conflict at your end, which should be strongly avoided, and all RPs should take a strong foot on these things that this needs not be our rule.
In fact, this circular should contain those provisions also of PG. That is what the first requirement.
What is your experience and opinion on the
No,
same?
see, I have been appointed by I can say, ICICI Prudential. That is not a bank exactly, but in term it is an IDBI trustee who has appointed me. But I have taken the assignment right from the beginning of just providing my report whenever it is asked and giving my report under section 100. Okay, because the initial process is to be done by lawyers. It is not our portrait. We are not lawyers, basically. So why should we enter into the field where lawyers are doing their good job?
So in case it is required, we can guide them, but don't take onus. Okay. We can guide them. We can help the institution in getting the things sorted out because it will ease our life only.
Right.
But for that, don't take the onus on us. My only point is not take onus on us.
I just want to add one thing.
Because I have not done.
So I just want to add.
I have given number of lectures on this, but I have not gone through this. How one gets into it.
So the process is very simple.
Yes, I think 8 to 10 lectures as a bankruptcy trustee, but this initial process I have not gone through.
So bankruptcy trustee, I don't think anyone has reached only.
No one has.
No one has reached so far.
It
I
is
think
just
what
a-
you
Then how to
are
get
need
into?
to reach.
अभी तक वो
What
passport
about
नहीं
your-
मिला है. How to land in that country?
अभी इसमें
It is the
भी
next
there are
stage.
two things,
It is like
NCLT and
liquidation
CRT.
stage, no? Bankruptcy comes with the next phase of liquidation.
That is correct, but I have not don't know how to
So
enter
that's,
to
no,
that.
that's what sir has said.
In this also there are two things. In individual insolvency, the CRP resolution process basically. One is NCLT, one is DRT.
I think let us repeat. I think see there is a question from the the people who want to enter into. So let us answer that. As you are all are aware, there is section 94 under which either the individual himself can go into insolvency or a resolution professional is appointed and he can file for the insolvency. 95 is the financial institution who are ready to who are filing the application for personal guarantor who has given the guarantee to the institutions. So there are two ways. Okay, the first way in which normally it is attached with the I think 95 96 nowadays people are attaching the consent of the RP in both the type of application.
Even application has to be with the consent of the RP, otherwise the A doesn't accept.
Form A, there are three forms.
Separate as like form 2 or form 2 only is used.
No, form 2 is only same.
It is again, to what I understand is different NCLTs are having different way. There is Form A, Form B and Form C. Form B is notice, after which Form C has to be issued. Form A and Form C has to be signed by insolvency professional. So I believe some NCLTs insist for Form 2, some NCLTs say that Form A and Form C has to be signed.
Yes.
Maybe we have a learned lawyer over here and there would be some others also who are lawyers. They could guide us on how various NCLTs are dealing on the same. Once the application is filed, after that, in my understanding, there is a resolution professional who is appointed who has to give a report under section 99. On basis of that report, the application is accepted. Now, when you are quoting the fees, whether if the application is rejected on the basis of report or even irrespective of what is mentioned in the report, application is accepted or rejected, RP has to work for that time. But is that amount included in fees? And if the application is rejected, who is going to pay the fees? That is again a great question area. Once the application is accepted, yes, please, sir.
When we talk that RP has to work on, in this what work you have to do?
No, I'll tell you.
Once the report is done,
Yeah.
till the time there is nothing to be done by RP.
Sir, but preparation.
Till the order is passed. In fact, there's a limit
Can you-
report in
Sir, let me share my personal experience because I am.
For report preparation,
He
you
is
will
being
require
saying
lot
that.
of information, lot of classification, drafting, all that is report might be 50 pages report hoga na?
No, sir. Once the order comes for interim, within 10 days the report has to be submitted.
Yes, we do not have time.
You don't have time.
Within 10 days.
And
we have
one
to
day,
submit.
once the report is submitted, then again that interim moratorium is there that time, and when the matter is heard and admitted based on the report, thereafter you take over the things and then the process
Then the
starts.
CRP starts.
That's the process starts.
First
But
interim.
what the point was raised that after report till this admission, there is actually no work.
Okay.
If you have something to say on that,
Yeah,
you share your experience.
But report preparation itself must be a
See, upon filing the application under 94 and 95, NCLT takes the first prima facie hearing. It hears the matter. If there is an objection from the opposite side, because we had a lot of objection from the opposite side also, that the companies under which this CRP is going on, he is likely to get the financial creditors are likely to get the entire amount out of the resolution process. So there is no need to invoke the personal guarantee and all this. Okay, so that has been challenged and it has gone to NCLT level also. But again, it came back and NCLT has restarted the button that you now restart it and you now they have asked RP to submit the report within 10 days. Okay, before our appointment, I can say before this submitting of report, the time during which NCLT the hearing is taking place, when you are filing the consent, you need to know who is the person to whom I am going against. Because whether he's a gentleman, he's a gunda type, or what kind of thing. Because ultimately it is a personal thing which which may come upon you. Because you don't know who is the person and how they are, how their education, what is their education, how, so to know that you have to take all the searches from the ROC website and all these things, where is director, from his DIN number, it is generated from DIN number. So we took all the searches from the website of the respective, ROC website, as well as whatsoever public domain, domain informations were there. So we try to take those information, form our opinion, okay, we will not have any problem even if this gentleman is, then we give a consent basically. And if it is the RP who is running the CRP process for the company, we even call to RP also that way how this gentleman is, whether I will not be having any problem, against going against insolvency or not. Please, yes, Nitinji.
Yes, Mr. Nitin, please, you can speak, sir. You are online, you can please speak. We were unable to hear you.
I think by mistake.
Mr. Hemant, you told that public domain you are talking, you are checking with the person background. So which type of?
I asked to my financial director himself, कि भैया ये बंदा है कौन? Basically, you at least let me know from your experience whether the company in which he is going to, CRP is going on. I also approached the RP of those companies. There were 2-3 companies which are under CRP. For this particular director, I have got 2 cases of individuals right now. One is at the level where, I have been already, the order under section 100 is already passed and I am moving ahead and I invited the public for the claim, and claim is already, I have received. And now we are in the process of, I already asked the person to prepare the repayment plan. And I am also in the process of filing the non-cooperation application under section 19(2) also. That's the thing apart.
19(2) तो इधर है ना, उधर भी similar होगा ना कुछ तो.
Yeah, non-cooperation basically.
Okay.
So this type of things are, there. So it is not only that, you sign के भाई कौन है बंदा कुछ जाने भी ना आप अगर, if you are entering into a, the grade.
Mr. Nitin, you wanted to speak something. You were again there. You spoke something.
No, I think.
What is the report that you are sharing? It's the assets and asset liability.
No,
That is stated there.
No, for personal
report under section 100 is purely based on the report which is received by your financial creditor about the debt which they as a personal guarantee, personal guarantor, the company has taken, whether the resolution plan has been received. If received, out of that debt, say for example 500 crore is the debt. Now out of that debt, what is the amount of resolution plan by which the debt is partly getting satisfied? For example, 100 crore resolution plan I have received out of 500 crore. So I have to say that they have to state that, and I have to also write the communication to the resolution professional who has undertaken that work, and from there also I have to take the feedback. So they are also attaching all the not only amount, the copy of resolution plan and everything they are attaching. Okay. So I have to ask them what is the amount, according to you, what is the amount due from this personal guarantor. After meeting the CRP of the company, or after having the whatever the liability of that particular company was there. So out of 500 crore, for example, 100 crore liabilities by way of resolution plan, what is the balance liability of this person? Okay. So after getting those confirmation from financial creditor, from from the companies under which they are director and which companies are undergoing for CRP process. Some of the CRP processes are still going on, so it is not been met with. Some of the CRP processes are already completed, but the amount is not realized by the person. So they say that still the date we have not realized a single penny out of it. Even though the resolution plan is there, it has been approved by Honorable NCLT, but still the amount is not received, or whatever amount they have received partially, they have to state that till the date I have received so much amount.
Hey, but so once committed, suppose I am a director.
Okay.
I have given personal guarantee. Just to make the thing easier.
Right.
My liability of company was 500 crore. I submitted the resolution plan for say 300 crore. Out of that 100 crore I paid. 200 crore I have to pay over a period of 3 years. So whether that 300 will be considered as received, or 200 only haircut is there, that for that only you will evoke personal guarantee, or for the 400 you will evoke because I have not yet paid 200.
Because you have not paid those 200, it will be for the entire amount, but stating that the amount which will be received during that process, if it is met with, then the amount has to be reduced to that
Process will be
extent.
over in 6 months. Suppose if he takes it from here also, then there what will happen?
He is individually personally liable for the complete liability. It is not
Correct, complete liability, but there my plan is approved say for 300 crore. I have paid 100 crore. 200 crore is pending.
So the bank will have to decide what is the demand notice they are going to
The
serve on this
demand
process.
notice, how can they ask when I have submitted a resolution plan is approved.
Praveen ji, in certain cases, resolution plans are approved by the, by the NCLT.
Yes.
Okay. And after 6 months from the implementation of resolution plan, the resolution applicant has already backed out.
Can I intervene?
Yeah.
I am the RP in the case of Alok Industries. Jivraj cars are the personal guarantors. I am the RP for the PG in that matter. Alok is a settled case. Now, how this process goes, when there are two things, DRT is there, NCLT is there. In our case, it was evoked after the process of CRP was over.
So DRT.
So it went to DRT. Mine is the first matter in DRT that has got admitted, and it is now hanging with Supreme Court. Okay. So in that, what has to be done? The report that what Hemant Bhai says, the first report that we prepare within that 10 days is to give the adjudicating authority idea whether this is a case of resolution of a personal guarantor or not. So whether there is a debt is the key aspect that they will see. The debt is unpaid, that they will see. Amount of unpaid, that is what they will see. Your point, pertinent point, what is unpaid debt for the PG? So once the resolution plan is passed, it is under implementation. So whatever the amount that is there in that plan, that is considered paid.
That is considered
paid.
Paid.
Till that time.
That is the only point, na?
Thereafter, balance. So in your case, as you said, 300 is the plan and 200 is outstanding. So 200 is unpaid. What Hemant Bhai said is the righteous way to report that total debt is 500, of which 300 is under implementation. And 200 is basically outstanding, for which the recovery proceedings under this resolution process for the PG is initiated.
Yes.
And whether this for 200, whether he will be able to go ahead on the resolution or not, that is to be decided in 30 days. So that is after admission. So first is the preliminary hearing.
First is the interim.
So the admission is for the only 200 crore, na? Not for 400 crore.
200.
Okay, now second important thing is, of late, maybe the principle of natural justice is also coming over here. Naturally, the application has to be given to the PG, but that is the personal guarantor. Second, even the report now has to be given to the personal guarantor, and he has full right to go into the report and challenge the report. Now, when the person is challenging the contents of the report, it is RP who is supposed to reply on that report. No one else can reply.
The RP who has prepared that report.
Yes, naturally, who else is going to prepare? So the work of RP is not as simple as it was earlier. He has to work into that, he has to reply into that, and he has to put his inputs.
So Devang Bhai, here I would add one more thing.
Please add.
So the key part is in report preparation is source of information and your presentation and how you draft your caveats. If you cover these things, whenever the question is raised by the honorable bench, you can answer that this is the source, this is what I have done, and this is what I have information. These are the information I had sought from the financial institution, from the PG. He has not given. But in this case, the 10 days reporting is compulsion. You cannot hold the reporting and, for the reason that I don't have information. Whatever information you have, collate it in a form of the order. Regulations are there. In regulation, what is required in this 10 days, this report that is there is clearly mentioned. So go by line by line. Take that as a para head, fill the details and cover up the things, put it across to the bench, let the bench decide. When the bench is deciding, they will call you and you have to get yourself be presented to say how you have prepared the report and give the insight to the bench. Once you give the insight, or based on that, they will take a call. So
when the 10 days period starts?
Thereafter admission happens and then that resolution process starts.
ये 10 days का period start कभी से होता है? घड़ी कभी start होती है?
जब भी NCLT appoints you as an RP.
Sorry.
On the date of communication of NCLT order to you.
तो जब भी बैंक अपने को अपॉइंट करती है तभी उसे सब इन्फॉर्मेशन
Yes,
ना
तभी लेने का
तभी
तभी
लेने
फॉर्म में भी बना
आपको
when you file
पहले
the
ground ready है।
application.
आप जब कंसेंट देते हो उसके पहले जितना आप जमा कर सकते हो डेटा कर लो।
और एक बैंक अपॉइंट करेगी तो वो बैंक नहीं, आपको उसके समझो पर्सनल गारंटी 4 बैंक होगी तो चारों का लेना पड़ेगा ना, जैसे आपका आलोक का है तो देयर माइट बी 10 बैंकर्स, तो 10 बैंकर से आपको पूरी इंफॉर्मेशन लेनी पड़ेगी पहले ही।
मेरे को सर 10 banks to be very simple, if you want to look into this process, we ourselves make sometimes this process complicated. This process is very simple. Okay, let's understand what is required. First, the bank takes the consent from us, then they apply to the adjudicating authority. Adjudicating authority will first hear it out. They will not admit it. After that, they will say who is the RP in this matter, and then they will issue an order to RP that in 10 days you prepare the report now. Okay. So at that time, till that time, from the consent till this time, you have enough time to collect the data. One. Let's assume that you have not collected. Then how to proceed? So the matter when it is admitted and the RP is given 10 days time, he has to collect data within 10 days. So he has to start from the day one collecting data from the first of all from the PG's place only. If PG is non-cooperating, as what Hemant Bhai said, if PG is not cooperative, you have to correspond with that. You have to create your documentation to that extent. So there can be a report in 10 days where the personal guarantor is not cooperating and you have not been able to collect exactly true facts from him. Because if you collect from various places, but not from the PG, as rightly said that the PG is to be also share the report and he is going to defend himself. So PG will come down on that ground stating that these are not the verified truth and the facts are different. And that is there in most of the cases. Because when banks use their claim and use their data, that data version and the data version of the personal guarantor will vary to a great extent. So you have to see that you get the version from the PG side at most. If he is not giving, then whatever you have collected from other sources, collect it in the form of a report and present it to the adjudicating authority, whether it is DRT or NCLT. NCLT, DRT will run through that report. Based on that, he will give the opportunity to the PG to defend himself. Once if he is able to defend and prove that no, that has not been due and he is not liable to pay that debt, matter is dismissed. If he is not able to prove, matter gets admitted.
There is one more point which happens in application. I believe there is some recent judgment also which Kirav or some another law could help, where even the financial creditors now are supposed to be given a copy of the application, and even they have the right to defend. All financial creditors. The reason being that individual insolvencies are being planned. Are being planned to thwart the efforts of financial creditors. That is why I believe there has been some judgment. I'll have to check on that, where all financial creditors also have to be given a copy of that order. It means even they may and come and oppose that application. In such circumstances, if we go on signing on for application form before an order directly to financial creditor asking for the details without any order, I'm not sure how many are going to oblige. Only after you have an order, within 10 days you have to compile that information.
No, but then based on your consent and application and appointment, whether the other financial creditor you can approach that I am going to propose.
Not on basis of consent, but on basis of order, maybe you can communicate.
Communicate order is a court order, but then once suppose I have given consent to Bank of Baroda, I cannot go to State Bank and say आपका भी लोन है तो आप दे दो detail मेरे को report देना पड़ेगा.
Usually जिस बैंक से आपने consent लिया है, you have to get the details from that particular bank.
So he will give up that bank only, na my loan. He will
not. You are also RP for that person for that purpose.
That bank, other you have to demand the PG.
The report does not contain the detail of assets, liabilities, anything at all. The report just contains that whether demand notice has been issued, whether personal guarantee was
only
there.
One bank.
So that is you are appointed only initially for only one purpose. Then when the things open up, when the actual order passes, then you are open for everybody.
You only have to prove there's a default.
So that you are not reporting for everybody.
And the case is suitable for being accepted.
No, there is a demand notice which is issued. You have been appointed, and when an application is filed, normally with the application you have also to sign.
Right.
So 90% of the information when you sign is already there. कि उसका क्या asset है, क्या
One
liability.
bank only, na. Suppose
But that is the bank which is appointing you.
But then now ultimately your 10 days report is for the
No. 10 days report is for this purpose.
1 minute. 1 minute. Application is filed to adjudicating authority by whom?
One bank.
One bank. Admission
Bank
of
of
this
Baroda
order.
is filed.
Admission of this order will be of
Only
whom?
for
One bank.
So that 10 days report will be of whom?
Only one bank. Naturally, the application
You have
contains
to,
details of only
in
one
this
bank.
report, you have to say that application. What is the RP's role? That application
अच्छा, तो you
contains
don't have
two
to
facts.
give his total
क्लेम देगा ना क्लेम देगा ना बाद
अभी आएगा.
वो तो बाद में आएगा सर. फाइनल एडमिट बाद में क्लेम
वो भी
बुलाऊंगा.
देना होगा तो देगा, नहीं देना होगा तो नहीं देगा. उसके ऊपर भी बहुत सारा ब्रेनस्टॉर्मिंग होता है, कमिटीज बैठता है और फिर डिसाइड होता है.
जब भी आप एप्लीकेशन देते हो उस टाइम पे आपको भी साइन करना है एज एन प्रपोज्ड आरपी कि भाई ये फॉर्म विदाउट द एप्लीकेशन बीइंग साइंड बाय द आरपी दिस प्रोसेस डज नॉट गो अहेड. सो हम बोल रहे हैं कि हम लोग बाद में रिपोर्ट करेंगे.
bank loan. I thought it is for the all bank loan.
And when you give that form
That report
contains
is
complete
only
details.
with respect to the application.
Application.
Whether
जो आदमी claim
application
किया
which
उसी
is
का.
filed can be admitted or not.
Based on that particular
Now I
requirement.
go, maybe you had asked second step also. There is a resolution plan of 300 crores, 100 crores has been paid, 200 crores is pending for a period of 2 years, and then 200 crores is unpaid.
Haircut is 200
And
crore.
haircut is 200 crores. Now, the application may be for 200 crores, or in my understanding, subject to, of course, testing on jurisprudence, it can also be for 400 crores. If the person says that I'm not paying this 400 crores, someone else is paying, if the person, this gentleman pays 200 crore rupees, he is stepping into the shoes of someone else. He gets the right to 200 crore rupees. So generally the resolution plan is maybe binding on everyone. So to what I understand, it will be only for 200 crore rupees. But even if it is for 400 crore rupees, the person steps into the shoes of financial creditor and he gets the benefit of that 200 crore rupees. So that person is anyway not losing.
Losing नहीं है ना, but then how can he demand?
Demand
Suppose
notice
मेरा
कम का ही हो.
मैं डिमांड कैसे कर सकते हैं? मेरी तो लाइफ पूरी हो जाएगी ना. मेरे पास समझो 300 करोड़ है, तो पूरा का पूरा लेके जाएगा तो मैं क्या करूंगा? मैं दूसरा बिजनेस ही नहीं कर पाऊंगा. मेरे से तू 200 करोड़ रुपया लेके जा, मेरे 100 करोड़ मेरे पास बचे, उसका मैं बिजनेस करूंगा वापस.
सर आपने गारंटी दी है ना लोन के लिए?
गारंटी तो पूरी दी है, लेकिन 300 करोड़ तो दे दिया था उसने.
ये वाली गारंटी वाले में बहुत सारे सुप्रीम कोर्ट का जजमेंट आ गया.
ये पूरा रिकवर कर सकते हो आप. पूरा 100%
केस में बोला है 100% कर सकते हो.
100%
लेकिन बाकी तो रिजोल्यूशन प्लान से मिल गया ना उसको.
रिजोल्यूशन प्लान इज नथिंग टू डू विद द पीजी. द सुप्रीम कोर्ट रूलिंग है इसका. रिजोल्यूशन प्लान आ गया, अप्रूव हो गया, कुछ भी होगा, आप पीजी के पास जाके पूरा अमाउंट ले सकते हो.
It has been clearly said in Anil Ambani case.
वो बोलेगा वो क्या नहीं इट विल नॉट बी डबल. वो खुद बोलेगा कि आपको ये मिल गया, ये नहीं मिला, अभी आप एडजुडिकेट करो. क्यों कम रिकवरी तो सबसे
आपको वहाँ पे रिकवरी हो गया ज्यादा तो यू आर बाउंड टू पे टू हिम ना. अल्टीमेटली आप डबल तो पैसा नहीं ले सकते हो ना.
रिजोल्यूशन प्लान हो गया तो तभी उधर 300 करोड़ रुपए तो प्लान एक्सेप्ट ही कर लिया ना.
Let's not go into ifs and buts. It's undecided.
I think with me is like when you are saying that you have given consent to the bank. Bank has appointed you. Bank have filed a report or a case before the NCLT Educating Authority that kindly appoint Mr. Rakesh as a relation professional. Once the hearing will be there for the they will decide whether the case should be admitted or not. But before that, they will say, yes, okay, I approve Mr. Rakesh Hussain to appointed as a relation professional for this PG. Then I get a 10 days time that I will prepare my report and submit it to the AA, and then he will decide whether the CRP will be started or not.
What I do, practically what I do, I will take.
It's an interim moratorium.
So interim moratorium is there, and during the first order. So first order when they give, then I will collect the data, or I can collect the data when my first form 2 is given. At that time, suppose SBI is given me, appointed me. So SBI say whatever information I can get, I will get. I will get the information from the other different sources, whether the PG we should take or not, or whether we should take this exercise of whether we should accept or not before giving my form 2. This is my question.
Rakesh ji, question is that only. कि भाई whenever you are getting an assignment of this PC type, you should be prepared ready to accept that 10 डेज टाइम में तो क्या है कि मैं बोलता हूँ मेरा 10 डेज के पहले ऑर्डर मेरा एप्लीकेशन अंडर सेक्शन 99 रेडी हो जाता है, मेरा रिपोर्ट रेडी हो जाता है, मुझे सिर्फ वो उसमें फिलिंग द ब्लैंक्स भरना पड़ता है बस। और इट इज द टेंडेंसी ऑफ इंडिविजुअल टू गिव द रिपोर्ट ऑन 10 डे नाइट एट 12 o'clock। मैंने देखा है, मेरे केस में हुआ है, वो 10वां दिन को रात को 10-12 बजे पहले ही आपको इन्फॉर्मेशन देगा, 11 बजे देगा, बोलेगा मेरे पास 10 डेज है ना, तो मैं आपको 10 डेज में दे जाऊँ, खत्म। मैं बोलूंगा भाई मुझे तो अभी इम्पोर्टेंट दे रहा, मैं कभी कंप्लाई करूं, मैं कल मेरे को फाइल करने का है। इट इज नॉट हैपनिंग इन दैट वे। सब रेडी होता है सर, because you are getting the information from the application which has been made to NCLT by your financial creditor, उसका एक कॉपी आपके पास आ जाता है, उसमें जो भी अमाउंट वगैरह सब लिखा है आपको सब रेडी रखना है, मतलब 10 डेज के पहले ही मेरे पास रेडी रहता है।
तो रिपोर्ट एप्लीकेशन बनी होनी चाहिए, एक ड्राफ्ट रिपोर्ट।
Sir, that application is
आपको
going to be a few pages. It is going to be a very bulky one.
सर मेरा एप्लीकेशन है ना 4 वॉल्यूम में गया था, 700-750 पेज में गया था, और बहुत केस में। हाँ 10 डेज रिपोर्ट नहीं, मेरा एप्लीकेशन नहीं, मेरा 10 डेज रिपोर्ट जो सेक्शन रिपोर्ट अंडर सेक्शन 100 है ना, वो 750 पेज में गया हुआ है दोनों केस में।
सर इन दैट केस व्हेन यू विल टेक
इस रिपोर्ट की रेशनल क्या है वो नहीं समझ में आ रहा। बैंकर फाइल करता है, ये बैंकर इज फाइलिंग इट and just like CIRP में they have to what they have to do, they have to establish debt and they have to establish default and date of default. These three things are established and it is admitted. तो इसमें रेशनल क्या है?
इसका रेशनल है, पीरियड इज लेस, तो वो लोग पहले से ही बनाते वक्त फ्रेम करते वक्त रेगुलेशन ऐसा बनाया कि हम ए के पास जाएंगे तभी रिपोर्ट के साथ ए को मालूम पड़ेगा कि इसको फटाफट कर देना, यस या नो। So that support is from our part to the AA under IBC to reduce the time frame.
यहाँ पे a lot of responsibilities which are there in CRP in AA has been given to RP.
To us.
Everywhere, I'm not going into individual sections. Virtually at every important stage, it is RP who has to report, and basis of report of RP, the executing authority takes decision. So that work has been deputed to IP. In fact,
default हुआ है, that is to be established by RP.
कुछ नहीं, डिमांड नोटिस गया, डिमांड नोटिस मिल गया, अमाउंट बराबर है, पीची बराबर है,
99 है, वो सब आप पढ़ो,
बस उसके 5-6 पॉइंट है, ज्यादा बड़ा नहीं है।
99-127 जो भी है ना,
उसमें लिखा है क्या आपने को करना है, कि रिपोर्ट में क्या चाहिए वो भी लिखा हुआ है।
तो वही फॉर्मेट में बनाना है आपको।
मना करूं कि मुझे केस नहीं लेना है, ये पार्टी अच्छी नहीं है या ये पीजी का हम केस नहीं एक्सेप्ट कर सकते।
पहली बात नहीं सर, वो एक्चुअली प्रैक्टिकली ऐसा होता नहीं है सर। आपको अगर आपने जैसे आपको है ना कंसेंट पहले देनी पड़ती है, जब आप EOI फाइल करते हो तभी आप कंसेंट देते हो, आपको मालूम ही नहीं है कि आपको मिलेगा कि नहीं मिलेगा, पहली चीज तो बराबर। दूसरा, जब तक आपको पास आता है तो 3-4 महीने हो के हम भी भूल जाते हैं हमने क्या दिया था, बराबर, ये दूसरा है। तीसरा, जब भी मिलता है तो आइदर यू हैव टू एक्सेप्ट इट और यू हैव टू रिजेक्ट। आप उसको ये नहीं बोल सकते कि मेरे को देखने दो आदमी, इनके लिए तो बड़ी चीज थी, इसलिए हमारे जो SBI जो बाकी सबके लिए हमको डील कर रही है, दे डोंट गिव यू एन अपॉर्चुनिटी, दे जस्ट सेड वी हैव इश्यूड दिस डिमांड नोटिस 4 months बैक, दिस इज व्हाट इज अवेलेबल, बस यू हैव गिवन ए कंसेंट, आर यू रेडी टू एक्सेप्ट, यस और नो। तो अपने पास उतना ही टाइम रहता है।
जो EOI होता है ना, तभी मैं देखता हूँ कि कौन सी इंडस्ट्री है,
एग्जैक्टली
कौन से लोग हैं, बराबर, और वो लोग का क्या पब्लिक डोमेन में इंफॉर्मेशन है, बाद में मैं SBI में फिट करता हूँ।
एग्जैक्टली, दैट इज हाउ वी हैव टू अप्रोच, दैट इज द परफेक्ट अप्रोच, दैट इज एग्जैक्टली दैट इज हाउ वी हैव टू गो कि इसके साथ में जाना है नहीं करना, वो पहला स्टेज पे परफेक्ट।
उस समय में उसका कहाँ से देख सकता हूँ? एक तो MCA देखा, फाइनेंशियल क्रेडिटर्स तो कुछ
टेक्सटाइल वाला है, आपको एक पैसा नहीं मिलने वाला।
सर आपको हम क्या बताएं, आप हमको बताएं कहाँ से क्या निकालना।
टेक्सटाइल वाला बंदा आपको अगर पर्सनली मिल जाए तो भी बड़ी बात है। टेक्सटाइल इंडस्ट्री होगी फॉर एग्जांपल, तो यू हैव टू जज फ्रॉम योरसेल्फ कि आपको कौन सी इंडस्ट्री का कौन सा बंदा कैसे लेने का है।
मिलने वाला ही नहीं है वो, तो हमको
कभी कभी बंदा मिलता ही नहीं है आपको। मैंने जब
Okay, sir, now the real challenge begins after the application is accepted. How will you get information of that particular person? अभी आप फोरेंसिक ऑडिटर है, बताइए। मैं तो आपको पूछ रहा हूँ सर।
बिगेस्ट क्वेश्चन, अभी एक बार चलो एप्लीकेशन का क्या फॉर्मेट है वो सब हो गया, उसके बाद में एक बार जब असाइनमेंट आ गया तो आप उसकी इन्फॉर्मेशन कहाँ से निकालेंगे, उसके बाद एसेट क्या क्या है?
एक मिनट सर,
डिपेंडिंग ऑन हिज
आप जब भी एप्लीकेशन से ही आप रिस्पॉन्सिबल है सर, ये डिफरेंस है RP नॉर्मल CRP। आप एप्लीकेशन साइन करते हो सर, आप बेसिक चीज भूल रहे हो आप नहीं एप्लीकेशन जब भी एनसीएलटी की एप्लीकेशन फाइल होती है तो एक फॉर्म सी होता है जो आप साइन करके देते हो कि मैंने ये देखा हुआ है। जब भी आप वो साइन करते हो तभी आपके पास सब इंफॉर्मेशन इंक्लूडिंग रिपोर्ट रेडी होनी चाहिए मेरे हिसाब से।
एग्जैक्टली फॉर्म
एसेट लायबिलिटी नहीं देखनी है।
आई एम आस्किंग आगे का क्वेश्चन कि एसेट की डिटेल कहां से निकालें?
एसेट की डिटेल आज के दिन पे तो आपको कौन देगा? आपको कौन देगा? जो बैंक है वही देगा। अभी मैं आपको बोलूं क्या तकलीफ होती है? नहीं एग्जैक्टली व्हाट यू से इज नॉट रॉन्ग, व्हाट यू से इज प्रैक्टिकल। मैंने बोला आप कहां से एसेट लाते हो? एक सिंपल है नेटवर्थ स्टेटमेंट मिलता है जो सीए साइन करते हैं, बराबर। वो नेटवर्थ स्टेटमेंट अभी आप बैंक को पूछोगे ना, बोला सर 2015 में लास्ट था, अभी 2020 चल रहा है, कहां से लाऊं? कुछ नहीं। दिस इज द प्रैक्टिकल फिगर। अरे आप वो छोड़ो, उसको बोलो पैन नंबर दो, ईमेल आईडी दो। वो पैन नंबर भी नहीं है, ईमेल आईडी भी नहीं है, एड्रेस बार इतना बार नोटिस भी यहाँ पे गया हुआ है। मैंने खुद नोटिस भेजी हुई है एज ए लॉयर, आई हैव टू सेंड नोटिस, वापस आती है। मतलब क्या करें? तो वो उनको पूछते वाला यही एड्रेस है हमारे पास। फिर वो जैसे ये लोग ने कहा यू कांटेक्ट द आईआरपी आरपी ऑफ द मेन सीआरपी लिक्विडेटर, उसको पूछो भाई इसके बच्चे कहाँ पे, आपने किसको कांटेक्ट किया, तो वो बताता है। तो बैंक को भी नहीं मालूम होता है फ्रेंकली, वो आदमी अपने को बताता है बिकॉज ही इज फ्रॉम आवर फ्रेटर्निटी। फिर वापस नोटिस दो अपनी ओर से कि कंफर्म करो ये चीज मिल रही, बिकॉज एप्लीकेशन की कॉपी भी सर्व करनी है। एप्लीकेशन की सर्व करके उनको देनी है अपने को एनसीएलटी को भी, ये एप्लीकेशन भी सर्व हुई है, नहीं तो पहले ही नहीं आएगा। एंड जस्ट टू एड टू द पॉइंट्स, नाउ द थिंग्स a lot of clarification has come from NCLT and NCLAT as well as Supreme Courts. अगर आप एप्लीकेशन देते हो तो that is not the stage wherein the matter has to be heard, only notice has to be served on the other part. जैसे एप्लीकेशन सर्व होगी अंडर सेक्शन 94 the RP has to be appointed. That whether the demand is proper or not and all those things is the next phase, not the first phase. तो अभी जो इनकी इश्यूज जो पहले आ रही थी अभी नहीं आएगी अपने को, provided you quote that case law when you are appearing or when your whosoever is the legal representative is appearing before NCLT कि ये केस लो है सर, आप प्लीज अपॉइंट कर लो, इतना महीना हो गया या नोटिस सर्व हो गई है तो what you have to ensure the other party has to remain present. अगर आ रही है अदर पार्टी, नोटिस सर्व होगी, अदर पार्टी अभी आप करो तो पहले आरपी अपॉइंट करो, 10 दिन में रिपोर्ट दो, उसके बाद में आप देखो बराबर है या नहीं है। तो ये प्रोसेस पूरा
अगेन डिफरेंट एनसीएलटीज आर फॉलोइंग डिफरेंट प्रोसीजर्स सर। Kirav, you can help on that. This may not happen every similar in all NCLTs. In different NCLTs again it will be different. So where you are signing and at that NCLT what is being followed again you'll have to check.
So I want to mention one point here.
What will happen at NCLT once you are appointed as RP?
So we'll go before that. See, what I'm going to say is, we are saying that the NCLT, the IP has to sign on application, it's not required. See,
no, without signing the application, they are not accepting.
Even the consent of the IP is not required with the application. If the applicant is not giving the name IP service, like in the case of operation creditor, similar provisions are there. So it's not necessary that IP's signature will go with the application.
Then someone from the user will be appointed.
Yes, it's there.
Register objection देगा, अगर फिर भी application चल रही है तो list में से कोई आ जाएगा.
Central Bank of India does not give any IP consent, and all the appointments are done from the panel.
Right, he's right.
So it's not.
What is the remuneration fee?
So those also see that's we have to decide when we give consent to IBBI. So
sir, in my case,
then 10 days तो अचानक जिस दिन आया उस दिन मेरे को 10 days report देना पड़ेगा.
So the first step is, I think sir will tell, but step is you have to immediately go to financial creditor who has filed the application. Take the application. Application has all the information. It has sanction letter. It has ledger statements. So basically, they also has to stabilize that there is a debt. So those informations are there, and applications are normally filed 1 year back. So you have to check between that 1 year to this period. You ask bank to give the ledger statement whether debt has been paid or not. We'll come to know. We write to the RP whether any resolution plan has been done or not. Write to the same day we need to write to this guy, the PG. He will also reply. If he doesn't reply in 7-8 days, I think we can consider that he is not paid. And normally you record the phones also.
बताओ उसमें की जो information इसमें copy करके देनी है तो ये second report का purpose क्या है?
This is because you are officer of the court. You are actually working on their behalf. So based on your report, they will take a call whether
but then if 90% of the information is same which the applicant has given.
But you are applying a blame, na? You are not applying.
Your role is scrutinizer. You are assisting the executive authority in scrutinizing this.
आपका जो requirement है सबका कि भाई कैसे है तो here there is RP has been given one more responsibility कि भाई आप prove करो ये है कि नहीं फिर मेरे पास आओ. Exactly वो हमको दिया था. To reduce the time frame. To reduce the time frame.
application ही copy करके
चेक क्या करता है?
बैंक एप्लीकेशन कॉपी नहीं होता है रिपोर्ट में. It is you have to strictly follow 99(1) to 99(7) or 8.
तो उसमें क्या क्वेश्चन है आपका डेट?
तो वो जो क्वेश्चन है उसको आपको each and every सेक्शन वाइज आपको जवाब देना पड़ता है.
2000 रुपीज एप्लीकेशन आपने पे करना था, वो पे किया है नहीं किया? दैट्स आल्सो
आप 99 सेक्शन रिफर करो, आप पढ़ो.
रेफर करवाते हैं. अच्छा, इसमें एक क्वेश्चन ये था कि आरपी का नाम देना जरूरी नहीं है. आपने पैनल में नाम हो तो वो किसी का भी नाम दे देते हैं.
नहीं, ऐसा सेंट्रल बैंक बोल रहा है, बाकी बैंक ऐसे नहीं.
सपोज ना सेंट्रल बैंक, आई एम टॉकिंग अबाउट सेंट्रल. सो सेंट्रल बैंक बोलो या एनसीएलटी. If the other bank have not given any name, IBB, sorry, our A will take any name from the our list. So list में से किसी का नाम उठा.
आप सेक्शन 99(1) to 99(9) पढ़ो, उसमें वही रिपोर्ट में वही फॉर्मेट में आपको रिपोर्ट देना है.
तो अब वही है.
उसके बाद में
अब सवाल ये है पीछे. अभी पीछे वाला ये है कि अगर सपोज को मेरे को अपॉइंटमेंट कर दिया तो मेरी फीस क्या होगी या मुझे इन्फॉर्मेशन कहाँ से मिलेगी. सपोज ए अपॉइंट कर रही है, आई एम नॉट टॉकिंग अबाउट द एफसी हैव अपॉइंटेड.
अभी एनसीएलटी में आपको कोई कहीं से आता है तो कैसे होता है? एनसीएलटी खुद बोलती है या बताती है? अभी वही बोलेगी.
अभी वही बोले तो फिर मेरे को 10 दिन ही मिलेंगे शिक्षा.
वो आपको तो अगर ये जिस तरह का उनका कहना है तो आपको 10 ही दिन मिलेंगे जहाँ पे आपको, और वो बहुत डिफिकल्ट स्टेज होगी क्योंकि आपको यू हैव टू इंश्योर एन इंटेंडेड
जाता है. बोलता हूँ,
लेकिन डेटा मिलना चाहिए ना.
आपको डेटा मिलना चाहिए, बाकी रिपोर्ट एक ही दिन में बन जाता है.
आपको फाइनेंशियल डेटा के पास जाना पड़ेगा.
इतना बड़ा रिपोर्ट बनाना है, बाकी तो सब डॉक्यूमेंट आपको अटैच करना पड़ता है. और कुछ नहीं है.
एसेट कहाँ से डिटेल मिलेगी?
सारी डेटा मिल जाती है.
क्या सर?
कुछ अलग नहीं है.
बराबर है.
आपके पास क्लेम्स तो आई नहीं है, बाकी लोगों का
बराबर है. परफेक्ट एग्जैक्टली बराबर बोल रहा है.
क्लेम के स्टेज में जाना है.
क्लेम के स्टेज में जाना ही नहीं, आपको कहीं और अप्रोच नहीं करना
है कि आपको इस पीरियड में कोई पेमेंट नहीं मिला.
परफेक्ट. पर रिपोर्ट को एस्टैब्लिश करना है.
उसके बाद ऑर्डर
नोटिस हुई कि नहीं, नोटिस हुई कि नहीं, बराबर इशू हुई कि नहीं अंदर आईबीसी. आप टिक मार्क जो करते हो ना पहले कि भाई नोटिस हो, जैसे मैंने कहा कोर्ट पूछती है कि नोटिस हो नहीं, उसको मिला कि नहीं.
एवरी क्वेश्चन विल बी आंसर्ड बाय 99(1) to 99(9).
पढ़ लो एक आप पढ़ दो.
Sir can read it better in a better way.
The resolution professionals shall examine the application referred to in section 94 or section 95. Section 94 is given by the bank. Section 95 is the debtor himself. I mean the party himself says that I am not.
Ulta.
94 is debtor and 95
is 95 one के अंदर बराबर. Yeah. As the case may be within 10 days of his appointment. ये एकदम सिंपल है सर, आपको पढ़ना है तो फिर भी मैं पढ़ लूंगा.
And submit a report.
And submit a report to the adjudicating authority recommending for approval or rejection of the application.
So I have to recommend also.
Yes, you have to recommend.
That is the main purpose.
Where the application has been filed under section 95, the resolution professional may require the debtor to prove repayment of the debt claimed as unpaid by the creditor by furnishing the following: एविडेंस ऑफ इलेक्ट्रॉनिक ट्रांसफर, पेमेंट हो गया इसके लिए. एविडेंस ऑफ कैश एनकैशमेंट, चेक दिया तो चेक या जो एनकैशमेंट हुआ है, साइंड एक्नॉलेजमेंट, पेड खाली जो पेमेंट हुआ उसका प्रूफ करो.
ऐसा नहीं है कि भाई.
So it means what? It means जब डेट दिया हमने, लोन दिया, उस समय का हमको प्रूफ करना है.
अभी का नोटिस देने के बाद, नोटिस देने के बाद
रिपे किया तो उसने कितना रिपे किया भाई?
अगर उसने रिपे किया तो सपोज करो, अगर मैं एक सिंपल एग्जांपल लेते हैं, अगर XYZ पर्सन ने बैंक को 100 करोड़ रुपए दिए और बैंक ने उसके अकाउंट को डेबिट नहीं करने की जगह डेटा सीधी के पर्सनल पीजी ने अगर 100 करोड़ रुपए दिए और बैंक ने उसके अकाउंट को डेबिट करने की जगह किसी राउटिंग अकाउंट में या किसी अनअप्रोप्रिएट अकाउंट में कहीं डला हुआ है, तो वो हम कैसे प्रूफ कर सकता है?
अरे सर आप एक्स्ट्रा ऑर्डिनरी सिचुएशन में मत जाओ, वो 100 में 1000 में से एक होती है.
हाँ,
तो आप टॉक अबाउट रिमेनिंग ना 99 की बात करो ना. अभी 100 में एक की बात क्यों करोगे?
सर 1% की बात करते हैं.
सर आप पहले 99 तो समझ लो, पहले बाद में एक की बात.
1% में सर अगर वो करता है
99 की तो समझ लो.
हमने 100 करोड़ दिया था और वो प्रूफ देता तो क्या आप मानोगे?
You have to prove यार. You have to prove बस खत्म सर.
You have to show bank statement and you have to confirm that. Confirm कर लो ना. अगर स्टेट बैंक को दिया तो स्टेट बैंक से confirm कर लो.
ठीक है.
लेकिन जैसे अभी आप बोल रहे थे पूरा लायबिलिटी देगा, वो चांसेस कम है, वो डिफॉल्टर है. फिर भी अगर दिया है तो आप बैंक से कंफर्म कर लो.
बस ठीक है. नेक्स्ट
Next point is whether debt for which the application has been filed by a creditor is registered with information utility. अभी information utility अभी आई है. मेरा experience ये है कि बैंक ने register नहीं कोई होता. ये तो पहले का loan होता है. जब CRP में जाता है तभी वो process चालू हो जाता है. तो basically they have still not registered or they are not using the information utility which was supposed to have been done. तो हम अपना comment pass कर सकते हैं. कभी registered नहीं है.
Okay, there is one. अच्छा, we'll complete this.
Doesn't matter.
Okay, now financial creditors are supposed.
Information utility.
Sir, financial.
We'll have to ask the banker कि भाई आपने information में दी है तो मुझे copy दो. हम तो इतना 10 दिन में नहीं कर पाएंगे ना, तो हमको फटाफट चाहिएगा नहीं. अपने पास 10 ही दिन है जहाँ पे रिपोर्ट देना है. So we cannot go to information, and information utility is not going to ask us unless we are registered for this purpose with them.
यदि वो किया होता है तो एप्लीकेशन के साथ ही लगा.
Precisely.
But see, financial creditor जो होगा, for CIRB, he has to compulsory register with information utility. But in individual creditor, in individual insolvency, there is no difference between financial creditors and other creditors. They are just creditors and there's just list of creditors. So when we are speaking of creditor over here, we don't have to consider only financial creditor. There could be other creditors and other creditors need not be registered.
पर्सनल गारंटी में तो खाली अभी यही है ना, जब भी वो पूरा इम्प्लीमेंट होगा तभी की बात है.
Personal guarantee, is it necessary that it will be only for financial creditor?
No.
For goods and material also I can give personal guarantee. Even he can trigger application.
नहीं
But now अभी तक तो नहीं है ऐसा.
अभी तो केस नहीं फाइल हुआ, लेकिन पीजी तो कवर्ड है ना. एनी काइंड ऑफ पीजी.
Any kind of PG.
एनी काइंड ऑफ पीजी सर.
आप कंप्लीट कराओ ना. ये कंप्लीट करो.
सर मेरे केस में जो फाइल हुआ है ना, बैंक ने नहीं किया है, कंपनी ने अपॉइंट किया था फाइनेंशियल क्रेडिटर ने.
हाँ
ओके.
हमने जो फाइल किया है पर्सनल गारंटी का, वो बैंक नहीं है, इंटर कॉर्पोरेट डिपॉजिट था, तो अदर देन एट बैंक्स.
किया ना, उसने भी किया ना, कुछ कर ही सकता है, कर ही सकता है.
Okay, next.
For the purpose of examination and application, the resolution professional may seek further information or explanation in connection with the application as may be required from the debtor or the creditor or any other person who in the opinion of the resolution professional may provide the information. तो हमको बोला गया आप ढूंढो, information निकालो और रिपोर्ट में डालो.
तीन ही लोग हो गए सर.
तो तीन ही दिया ना, डेटर क्रेडिटर और एनी अदर पर्सन, एनी अदर.
ये तो उसके आरपी से पूछ लो
बस. और प्रिसाइसली ये तीन के ऊपर कोई और 99% ना आपको आरपी दे सकता है और फाइनेंशियल क्रेडिटर भी देगा और कोई आपको वो
ज्ञान देता नहीं.
पर्सन देता है.
आरपी देता है, सब देता है.
आरपी देता है पर पर्सन
उसको
जो पीजी वाला है वो नहीं देता है. वो पीजी वाला तो वैसे भी डर जाता है. क्या
कार्ड का कॉपी भी आ जाएगा सब.
सर हुआ होगा. रेजो प्लान का कॉपी कैसे देगा?
मिला है.
सर बट वेदर
आप अकाउंट हो जाते हो ना तभी वो दे सकता है.
आप केस लॉ पढ़िए, रेजोल्यूशन प्लान आफ्टर पासिंग इज पब्लिक डॉक्यूमेंट. अभी क्यों नहीं देगा? इज अ पब्लिक डॉक्यूमेंट आफ्टर पासिंग. इट इज अ पब्लिक डॉक्यूमेंट. आप केस लॉ पढ़िए.
ऑफिशियली देता है और ऑफिशियली वी आर फाइलिंग इट टू एनसीएलटी आल्सो along with the report.
After passing of resolution plan, it becomes a public document. There is a case law.
एनसीएलटी में जाके लिंक डाउनलोड कर सकते हो.
You can apply to NCLT. आपको मिल जाएगा.
If you are a stakeholder.
If I am a researcher, I want to see the report.
RTI में मिल जाएगा.
Here there is a question of personal guarantee, so they are the stakeholder. They have to establish it. So it's okay. I think you can go ahead, please. I think otherwise, we are running out of time. तो अपना एक दूसरा चैप्टर रह जाएगा.
The person from whom the information or explanation is sought under subsection 4 earlier section shall furnish the information or explanation within 7 days of the receipt. यानी अपने को उस हिसाब से उसको बोला गया 7 दिन में आप रिपोर्ट करो.
तो मतलब पहले दिन आ जाए तो उसके दूसरे दिन ही आप मेल भेज दो.
हाथों ईमेल.
हाथों ईमेल भेजो.
मेरे हिसाब से तो ये सब चीज पहले ही कर लेनी चाहिए अपने को.
हमारा तो ऑर्डर प्रोनाउंस हो गया था, लेकिन मुझे 15 दिन के बाद मिला.
उस बीच में कर सकते हैं.
मैंने क्या लिखा, सबको लिख दिया कि भाई दिस ऑर्डर हैज बीन प्रोनाउंस्ड इन द कोर्ट. However, we are awaiting for the final copy of the order. However, we request you to kindly compile this data and give me your report. Once the official order will be communicated to me, I will provide you the copy of the original. तो मुझे फाइनेंस क्रेडिटर ने दे दिया 15 दिन पहले, बराबर है. और वो जो इंडिविजुअल के जो अपने थे उसने लिख दिया लॉयर ने कि भाई लेट अस हैव द कॉपी ऑफ फॉर्मल ऑर्डर, देन ओनली वी विल प्रोवाइड यू द इन्फॉर्मेशन. फिर बाद में जब भी उसका कॉपी आया, बाद में बोला कि अभी वी हैव गॉट इनफ टाइम, 10 days टाइम. मैंने उसको कॉपी भेजा, बाद में मैंने बोला कि भाई विथ रेफरेंस टू माय मेल सो एंड सो डेट आई रिक्वेस्टेड यू काइंडली प्रोवाइड द डिटेल. सो आई रिक्वेस्ट यू नाउ दिस इज अ फॉर्मल ऑर्डर, सो आई रिक्वेस्ट यू टू गिव मी डिटेल विद इन 2-3 days करके. अच्छा, उसने क्लियरली लिख दिया कि भाई 10 दिन है ना मेरे पास, व्हाई शुड आई गिव यू विद इन 2-3
7
days?
दिन ही है ना।
हाँ जो भी 7 दिन, मतलब सी अल्टीमेटली दे सेड कि भाई उसको तो लास्ट मोमेंट पे ही देने का है, मतलब बेसिकली आप समझे? So this is what is practically happening.
Point number 6, the resolution professional shall examine the application and ascertain that A, the application satisfies the requirements set out in section 94 or section 95. B, the applicant has provided information and given explanation and sought by the resolution professional under subsection 4. Applicant यानी financial creditor. ये दो चीजें 6 हो गया. अभी 7, after examination of the application under the subsection 6 जो ऊपर है, he may recommend acceptance or rejection of the application in his report. Where the resolution professional finds that a debtor is eligible for a fresh start under chapter 2, इसमें होता नहीं है ज्यादा, the resolution professional shall submit a report recommending that the application by the debtor under section 94 be treated as an application under section 81. Fresh start हो नहीं रहा है. The ninth point is the resolution professional shall record the reasons of recommending the acceptance or the rejection of the application in the report under section. नहीं डिमांड नोटिस गई है, अपना पर्सनल गारंटी है, इन्वोक हुआ है, विद इन 3 इयर्स लिमिटेशन पीरियड के अंदर आ गया है, उसको नोटिस सब हुई है, हमने भेजी, उसको मिल गई, 4 चीज होगी. सीआरपी तभी का रिक्वायरमेंट आके सीआरपी या लिक्विडेशन चलना चाहिए. अभी तो सुप्रीम कोर्ट ने बोल दिया है कि सीआरपी लिक्विडेशन नहीं चल रहा है तो भी आप कर सकते हो. तो मैटर एंड्स देयर, यू रिपोर्ट इट एंड फिनिश इट ऑफ. 4-5 पॉइंट
एक्सेप्ट. और डेट साइज इतना है ना, डेट लिखना पड़ेगा ना
आपको. जो डिमांड उसने रेस किया है उसी पे आप लिख रहे हो. आपको आपकी विद इन योर लिमिट्स यू टू राइट. उसने डिमांड 100 करोड़ किया तो आप 100 करोड़ के लिए लिखेगा. उसने डिमांड 200 करोड़ किया आप 200 करोड़ के लिए.
इसमें भी व्हाट बाय एक्सपीरियंस है, इसमें क्या था कि पर्सनल गारंटर का समझो एक कंपनी में 55 करोड़ का डेब्ट था, एक कंपनी में 45 करोड़ का था. तो दे सेड के भाई कंपनी उसमें देयर वर 2 कंपनीज व्हिच आर सीआरपी वर गोइंग ऑन. तो उन्होंने बोला कि ये 2 कंपनी प्लस तीसरी कंपनी में से भी पैसा आना था. तो दे सेड के भाई ये 3 कंपनी से मिला के मेरा टोटली जो डेब्ट 100 करोड़ का है वो हो जाता है, तो आई एम नॉट लायबल टू पे करके. लेकिन द स्टेटस वाज लाइक दैट, यू नो, एज ऑन द डेट ऑफ रिपोर्ट दैट वाज नॉट द फैक्ट. वो तो बाकी है ना. सो वी हैव टू गिव द एंटायर फैक्ट टू द ए कि भाई दिस इज हाउ द यू नो दे आर प्रपोजिंग. इसमें 2 कंपनी में रिजोल्यूशन प्लान था, लेकिन एट लास्ट मोमेंट मुझे पता चला कि जो दूसरा रिजोल्यूशन प्लान था उसमें रिजोल्यूशन एप्लीकेंट हट गया खुद. ही इज बैक्ड आउट फ्रॉम हिज प्रपोजल. तो अभी वो प्रोसेस अभी वापस रीबटन उसको री एंटर करना है पूरा बटन पूरा. तो ऑल दिस हैज टू बी मेंशन प्रॉपरली so that you know it will be very clear picture to the AA during admitting the report also. ठीक है.
Yeah, point number 10 is that the resolution professional shall give a copy of the report under subsection 7 to the debtor or creditor as the case may be. जिसने अप्लाई किया वो छोड़ के जो दूसरा पर्सन है उसको भी देना चाहिए. आप दोनों को ही देना चाहिए.
अप्लाई कर सकता है ना, क्रेडिटर्स भी अप्लाई कर सकता है, दोनों कर सकता है इसको. 94
दोनों को दे देना चाहिए. डेटर और क्रेडिटर लिखा है, एंड आप कर दो.
प्रॉब्लम तो कॉपी दे दो.
तो एक और क्वेश्चन, यहाँ पे अगर केस फाइल किया है, एसबीआई फाइल किया है, 4 और बैंक है, तो मेरे को सबको देनी चाहिए कि
डेटर और क्रेडिटर ही लिखा है.
The resolution professional shall give a copy of the report.
यहाँ पे डेटर और क्रेडिटर लिखा है, but there is a judgment
to the debtor or the creditor. तो CRP
where you have to give it to every financial creditor.
डेटर और
अरे सर आपको मालूम ही नहीं आज की डेट में कौन फाइनेंशियल क्रेडिटर है, वो कैसे मालूम पड़ेगा? आज की डेट में मालूम ही नहीं.
मैं तो दोनों को देता हूँ सर. जो एप्लीकेंट है उसको तो देता ही हूँ, जो पीजी है उसको भी देता हूँ.
नहीं मैं कह रहा हूँ सर एप्लीकेंट के अलावा
बिफोर सबमिटिंग टू एनसीईआरटी आई गिव इमीडिएटली टू दिस, बिकॉज वहाँ पे लिखा है प्लीज सबमिट. जो ऑर्डर आता है ना एनसीईआरटी का उसमें लिखा होता है प्लीज सबमिट अ कॉपी टू द पार्टीज ऑल्सो.
रिपोर्ट को कॉपी सबमिट करते हैं.
तो दो वोट या ना, एक डेटर एक क्रेडिटर.
लेकिन क्रेडिटर्स को करते हैं सब लोग.
डेटर्स या ना
क्रेडिटर्स एक्चुअल करते हैं मतलब एप्लीकेंट
ने मैंने दोनों को यहाँ पे तो और ही लिखा है, डेटर और क्रेडिटर ही लिखा है यहाँ पे. मैं दोनों को कर देता हूँ, नोबडी शुड ऑब्जेक्ट.
So here, as the case may be, would imply whoever is the applicant.
Normally the applicant is a person who is appointing you also. He is also going to AA. So naturally he expects that the report copy should come to him also. जैसे applicant. So वो तो है ही. That is, I mean, it is your concern. But if you give it to the other person, there is no harm. वैसे भी copy का report. End of the day, it is NCLT who is going to pass a मेरा रिपोर्ट से कुछ उसको फर्क नहीं पड़ने वाला है जब तक द ऑनरेबल एनसीएलटी डज नॉट अप्रूव और डज नॉट ओके दिस इज जस्ट अ रिपोर्ट देयर इज नो हार्म इन शेयरिंग
कुछ सर ए अपॉइंट करना है ए ने अपॉइंट किया फीस कुछ लगता है लोग
नहीं फीस नहीं तो इसमें राइट फ्रॉम डे वन यू हैव टू बी एसोसिएटेड देयर इज अ लिटिल डिफरेंस आप जब भी नॉर्मल सीआरपी का केस लेते हो जब भी एडजुडिकेटिंग अथॉरिटी आपको अपॉइंट करता है तभी आप वो लेते हो इसमें ऐसा नहीं है आप एप्लीकेशन मैं तो बोल रहा हूँ एक स्टेप पहले आपको नोटिस में भी इन्वॉल्व होना चाहिए बिकॉज मेनी टाइम्स द बैंकर्स है उनके पास पर दे आर नॉट अवेयर ऑफ हाउ टू रिप्रेजेंट मैं बोल रहा हूँ ना पूरी एप्लीकेशन की कॉपी नहीं दी है दूसरी बात से मुझे रिप्लाई आ रहा है कि आपने एप्लीकेशन दी अंदर का डिटेल किधर दिया है
Sir, there have been some large profile cases.
Starting से involve होंगे. You have no rights to like a PG with only a person. You cannot take.
आपको पीजी को बोलने की जरूरत ही नहीं है आप तो फाइनेंशियल क्रेडिटर को हेल्प कर रहे हो ना एप्लीकेशन बना रहे हो उसमें सब डिटेल है एसेट की डिटेल वो लिख रहे हो
कौन देगा
जो फाइनेंशियल क्रेडिटर वो देगा तभी देगा
1 लाख रुपए होता है वो कब देगा लास्ट में देगा जब केस एडमिट हो जाएगा तब
केस एडमिट नहीं जब पैसा आएगा पीजी से तब देगा
वो नेगोशिएशन
पीजी का बात करो होता है केस एडमिट के बाद योर रूल्स स्टार्ट है
वो तो डिफिकल्टी अपने प्रोफेशन में है ही किसी को पैसा देना है नहीं आप नॉर्मल सीआरपी ले लो
बात नहीं कर रहे एक्चुअली होना क्या चाहिए
Once the first report, NCLT asked me to submit the report. NCLT say कि भाई कौन resolution for bill चले, तभी मैं नीचे में आता हूँ, तभी उसके पहले मैं किचन में नहीं आता।
मेरे को फीस कब से मिलेगी? फीस तो मेरे को मिलेगी जब मैं सीआरपी एडमिट होगी।
सेक्शन 100 का रिपोर्ट हो जाएगा, सीआरपी एडमिट हो गए उसके बाद।
एडमिट हो जाएगा उसके बाद, तो उसके पहले की जो सेवा है वो समाज सेवा है।
हाँ वो आपका फीस है, आपको समझने के लिए।
समझने के लिए।
नहीं एक मिनट सर अगर आपने रिपोर्ट दे दी और केस एडमिट नहीं हुआ तो आपने ऑर्डर आ गया उसको नहीं मिलेगा ऑर्डर आ गया
नॉर्मली इधर what I used to quote is the lump sum fees.
अच्छा lump sum fees.
ऐसा नहीं कि भाई मुझे पूरा प्रोसेस कंप्लीट करना है अप टू सीआरपी मतलब आईआईआरपी इंडिविजुअल इंसॉल्वेंसी प्रोसेस ओके बाद में बैंक्रप्सी प्रोसेस का अलग चीज है बट अभी आईआईआरपी मुझे करना है तो आई से कि भाई आई विल चार्ज x लाख रुपीज और y लाख रुपीज ओके फॉर द एंटायर प्रोसेस ऐसा नहीं बोलता हूँ कि मैं पर मंथ इतना लूंगा इससे मेरा प्रैक्टिस वो है मतलब आई फॉलो दैट प्रैक्टिस आई डोंट नो
नॉर्मल पीपल आर चार्जिंग मंथली फॉर
मंथली का जब
एडमिशन होता है फर्स्ट ऑर्डर
इसमें एडमिट का स्टेप एक और बात का स्टेप है केस एडमिट हुआ है नहीं वो नेक्स्ट स्टेप है जब आप रिपोर्ट दोगे तभी वो डिसाइड करेंगे एडमिट के लिए द प्रोसेस इज लाइक
राइटर साइड इनका जो लमसम होगा ना केस का इनका पर मंथ होगा
बट
बेसिकली
चलते हैं आप
हाँ प्लीज बताइए
उसके आगे के स्टेप पे बढ़िए सर केस एडमिट होगा तो आगे क्या होगा दो चीजें समझनी है क्लेम एडमिशंस का और एसेट कहाँ से मिलेगा वो समझना
okay sir now here the notice has to be given of 7 days notice for invitation of claims CRP 5 liquidation CRP 3 liquidation 5 you have 7 days notice here the notice is supposed to be given by adjudicating authority on its website and its premises but the adjudicating authority generally IP को ही बोलता है आप दे दीजिए तो वो आपको देना है तो जब भी आप कोटेशन देते तो वो भी सब आपको क्लियरली लिखना है नहीं तो बाद में क्वेश्चन नहीं आना चाहिए कि भाई नोटिस आपको नहीं देना तो आप क्यों खर्चे में डाल रहे हो तो जब आप खर्चे का कोटेशन देते हो तो वो भी आपको कैलकुलेट करके रखना है सेकेंड चीज 7 दिन में आपको नोटिस आएगी उसके बाद 21 दिन तक क्लेम इन्विटेशन है और 21 दिन में आपको रिपेमेंट प्लान बनाना है वो रिपेमेंट प्लान के लिए अभी असेट्स एंड लायबिलिटीज डिटेल्स चाहिए असेट्स एंड लायबिलिटी डिटेल्स सर यहाँ से सीनियर से शुरू कर दीजिए यहाँ तक बताइए सबके आइडिया कंपाइल करके हम लोग आपको बताएंगे
लायबिलिटी तो सब आ जाएंगे सर देने के लिए बता देंगे सर 2017 से
सब एक सिंपल चीज है लायबिलिटी सबसे ज्यादा अपनी कौन बताएगा इजीली बताएगा
नहीं है सर जिसने दिया उसकी जिम्मेदारी है वो नहीं करता है क्लेम तो अपने क्या करे बट एसेट का क्या करे कहाँ से लाए
सर जब आप एप्लीकेशन फाइल करते हैं ना तभी एसेट की डिटेल उस बैंक के पास जो होती है वो मिल जाती है
उसमें सब गायब होती है
सर यहाँ
कुछ नहीं कर सकते सर वो अपने हाथ में थोड़ी है उनको जादू की छड़ी तो नहीं है लेके
बता दीजिए मेरे उनके पास तो एसेट नहीं है
एप्लीकेशन फाइल होती है ना तब एंट्री मोरिटम चालू हो जाता है तो एंट्री मोरिटम में ये नहीं लिखा हुआ है कि ही कैन नॉट सेल ही कैन नॉट डिस्पोज द एसेट्स सबसे बड़ी चीज है
बैंक कैन नॉट स्टार्ट एनीथिंग, जब बैंक के लिए रिस्ट्रिक्शन है
कोई भी नहीं, पीजीबी
कोई भी नहीं कर सकता ना।
पीजीबी नहीं बेच सकता।
सर रिस्पॉन्सिबिलिटीज ऑफ डेटर देख लीजिए, सब रिस्पॉन्सिबिलिटीज आफ्टर क्वार्ड एसएच की भी है।
बेसिकली वी विल हैव टू मोटिवेट हिम कि भाई कोई रिजोल्यूशन प्लान बना, फटाफट कर, नहीं तो तेरा जाएगा बैंकरप्सी में।
बट वो बोलता है मेरे पास कोई एसेट ही नहीं है।
एग्जैक्टली ऐसा ही होता है, बहुत बार ऐसे ही होता है, मतलब जितना था उतना तो दे दिया।
2000 रुपए का बैलेंस होगा, व्हाट यू विल डू?
एज्यूम करें सर उसके पास एसेट्स है, बिजनेस है, वो कर रहा है, लेकिन अभी उसके साथ यही किया तो बिजनेस को सेल।
सर उसको रिजोल्यूशन प्लान बनाते वक्त वो बोल सकता है मैं 5 साल में रिपे करूंगा, मैं 10 साल में रिपे करूंगा, वो रिस्ट्रिक्शन नहीं है। वो बनाएगा प्लान, अगर क्रेडिटर को एक्सेप्टेड है तो एक्सेप्टेड है। वो बोलेगा मेरा घर का खर्चा इतना आता है, मेरे को शादी करना, ये करना, वो करना, फलाना ढिमका, तो मैं इतना पैसा बाजू में रखता हूँ, हाँ बाकी का मैं देता हूँ आपको। तो इट इज फॉर द क्रेडिटर टू एक्सेप्ट। वी आर जस्ट अ फैसिलिटेटर, जो पहले थे वैसे ही है हम लोग।
सर उसके पास असेट नहीं है, बैंक अकाउंट में 2000 रुपया है, आप ये सोचिए देन व्हाई इज अ फाइनेंशियल क्रेडिटर creating so much of cost in imposing individual insolvency guarantee, individual insolvency.
तो formality कर रहा है। He has to run the process. He has to run the process. Bank has to do it.
So there are some agencies which they can help us out to know कि उसके पास है कि नहीं है, उसके लिए जो खर्चा है वो बैंक को देना पड़ेगा।
वो एजेंसी कैसे सर्च करती है?
जैसे फॉरेंसिक ऑडिटर होते हैं वैसे उनको मालूम होता है कि भाई
सर है ना फॉरेंसिक ऑडिटर अपने पास, एक यहाँ पे एक यहाँ पे है।
नहीं, वो लोग पीछे जाते हैं सर। व्हाट डिड वी गो 2 years back 3 years back and try to find out, because उनको तो मालूम है सीआरपी स्टार्ट हो गया है।
Is there any obligation there from the government agencies to provide information?
अभी इनकम टैक्स में जाके
that we can write to income tax department that please provide the information. इनकम टैक्स डिपार्टमेंट में तो होगी।
अरे इनकम टैक्स क्लेम नहीं देता है, आप बोल रहे हो उसको इन्फॉर्मेशन देने को, क्लेम देने के लिए 4 बार दौड़ गया।
मांगिए तो सही।
अरे वो रिफंड भी नहीं देगा, तो कब देगा?
इनकम टैक्स में कब इन्फॉर्मेशन होगी जब उसकी एसेट्स इनकम होगी तो देगा वो। अगर इनकम टैक्स में जरूरत क्या है?
नहीं, पर आप मांग सकते हो ना, आप जो नहीं, पहले तो पीजी से मांगो ना, तुमने इनकम टैक्स रिटर्न भरा है, वहां से स्टार्ट करो ना।
रिटर्न भरा है क्या? ये भी देंगे।
बैंक गारंटी लेटेस्ट हमें एसेट तो होना चाहिए ना बैंक के हिसाब से। कोई आदमी मंगा तो बैंक गारंटी देगा नहीं,
वो ले लेता है।
बैंक गारंटी
होता क्या है सर, होता क्या है, ये सब प्रोसेस है ना इनिशियल स्टेज में हो जाते हैं।
अगर 100 करोड़ तो मडी दूसरी पर्सनल गारंटी 100 करोड़ वो भिगमंगा तो नहीं रहेगा ना। 100 तो बैकअप
होता क्या है, लोन जिस डेट में पीटी देते हैं उसके बाद में वो सारे एसेट यूज हो जाते हैं,
अगले दिन सब गायब हो जाता है।
अगले दिन सब गायब।
तो बैंक का फ्रॉड है, बैंक ही फ्रॉड कर रही है और क्या। मतलब एक 100 का बैंक का उसको पता नहीं, ऑफिसर उसको पता नहीं, ऑफिसर ही
नहीं, ये एक्चुअली बैंक को नहीं बोल सकते ना, वो तो सीए सर्टिफिकेट भी होता है। सीए सर्टिफिकेट भी होता है, कोई भी पूरे प्रोसेस में किसी कोई भी बैंक हो सकता है।
देने वाले को आप बोलो कि 2000 रुपया क्या है, तो ये तो बहुत बड़ा।
आप किसी भी एक जन को
नहीं, इसका मैं
पूरा सिस्टम
आपको जवाब देता हूँ। वो क्या है कि सपोज मेरे पास 100 करोड़ है और मैंने 500 करोड़ का लोन लिया, फिर 100 करोड़ हो गया। मैं बोला मैंने तो अपना 100 करोड़ ये कंपनी में लगा दिया कैपिटल में, अभी मेरे पास कुछ नहीं है, बट विल द बैंक एक्सेप्ट मी फ्रॉम गारंटी? नो, आई हैव टू साइन इट। तो प्रैक्टिकली अगर मैं 100 करोड़ लगा रहा हूं तो मेरे पास कुछ ना कुछ एसेट होगा, बट थ्योरेटिकली अगर मेरे पास 100 करोड़ है, मैंने 100 करोड़ लगा के कंपनी शुरू कर दिया, आपने वो 100 करोड़ देख के 400 करोड़ लोन दे दिया, 500 करोड़ हो गया, अभी मेरे पास कोई बचा नहीं अभी। तो दैट सिचुएशन इज पॉसिबल, ऐसा नहीं है कि नहीं पॉसिबल है। और दूसरा क्या होता है, जब लोन सैंक्शन होता है और जब लोन खराब होता है उसमें डिफरेंस बहुत होता है। तो आपने सैंक्शन करवाया, आप उसको जो बोलोगे वो लिख के देगा। उसके बाद जब उसका नेटवर्थ रिपोर्ट है, पर्टिकुलरली इन ओल्ड केसेस द नेटवर्थ रिपोर्ट बाय द बैंक्स वाज वेरी वेक। अभी तो थोड़ा सा फिर भी बैंक्स थोड़ा इंफॉर्मेशन देते हैं, उस टाइम पे वो ऐसे ही लिखता था इतना एसेट मेरा 5 करोड़ का एसेट, 2 करोड़ का लायबिलिटी, 1 लैंड, उसका भी आधा डिटेल होता था, नहीं होता था। एंड सपोज दैट इज ऑफ 2006, आज आप 2022 में बैठे हो, यू कैन नॉट प्रिज्यूम कि वो सेम होगा। तो दैट इज द प्रैक्टिकल डिफिकल्टीज इन बिट।
जल्दी कुछ होता नहीं।
दूसरा बैंक का भी क्लेम जब भी बैंक कर रही है तो आई हैव ऑब्जर्व्ड दैट उनको कुछ रिकवरी हो जाती है, उसके बाद में अमाउंट तो उतना ही है, उससे डबल ही होता है। सो बैंक भी पूरा पेनल्टी ये वो लेके 100 रुपए के बदले में 500 रुपए लेती है।
ये बात तो सही है।
और जब एनसीएलटी के पास हम जाते हैं बोलते हैं 500 का 10 रुपया मिला, पर सर 10 पहले से ही 100 था, उसमें से 10 मिला, बाकी 400 तो एडिशनल चीजें है जो पेनल्टी फाइन ये वो करके लेके आए।
पीजी में हम लोग इतना
ICICI बैंक का 96 करोड़ का एक्चुअल लोन था, उसका क्लेम फाइल हुआ 2000 करोड़, अभी 96
करोड़।
मेरे
पास एक असाइनमेंट
इंटरेस्ट एंड पेनल इंटरेस्ट डाल करके 99 का केस था और अभी जाते जाते 20 साल में 2000 करोड़।
नहीं, मेरे पास भी एक ऐसा केस है जहाँ पे बैंक ने पूरी रिकवरी कर दी है।
मेरे केस में
और सीआरपी ऑर्डर हुआ, तो अभी सीआरपी ऑर्डर के एसेट सब बिक गए हैं, सरफेसी में चले गए सब चीज। अभी सीआरपी ऑर्डर हुआ, सीआरपी ऑर्डर में एवरी बैंक इज ट्राइंग टू क्लेम द मैक्सिमम अमाउंट, तो मेरा क्लेम है 120 करोड़ का। जब भी आता है आरपी का फीस देने का, किसी का फीस देने का, मतलब एसेट किधर है, मतलब सर तो क्लेम क्यों दिया आपने? मेरा बोला नहीं, क्लेम तो हमारा राइट है, मतलब ठीक है, फी कितनी दोगे? 5000 रुपया आरपी की, मतलब सर आपको जो 5000 रुपए में चाहिए ले लो, मेरे को नहीं रखना है। बोला हम दूसरा रखेंगे भी नहीं।
हाँ रखेंगे भी नहीं, हाँ बस यही चल रहा है।
बोलते आपको जहां से लाना है लाओ, मतलब मेरे पास रिक्वायरमेंट है, करें क्या? This is a factual information. I told that I have written to IBB, I have written to everybody.
सर आपने उस केस में IBB को लिख दिया, मुझे भी लिखना है।
हमको बोल रहे करने के लिए क्या करें? प्रोसेस में रखूंगा, जितना मेरे से खर्चा होगा मैं करूंगा भी, वो देगा तो ठीक है, नहीं तो एनसीएलटी से रिकवरी करूंगा।
अभी पीजी अच्छा ऐसा है क्या? मेरे को बताओ, एक मेरे को भी चाहिए
पर्सनल गारंटी का
नहीं, नॉर्मल सीआरपी है सर,
एनसीएलटी ने अपॉइंट किया,
इंडिविजुअल का पूरा है।
एनसीएलटी ने अपॉइंट किया या किसने अपॉइंट किया?
नहीं अपॉइंट दूसरा फाइनेंशियल क्रेडिटर ने किया।
वो फाइनेंशियल क्रेडिटर नहीं दे रही,
मेरे केस में नहीं दे रहा।
तो 10 लाख का है
उसमें आपको
सर मेरे फाइनेंशियल क्रेडिटर
क्या वजह से
तो ये सब सामान्य
आप क्लेम दिया 10 करोड़ का,
90%
हम एक्सेप्ट क्यों करते हैं?
पर हम एक्सेप्ट कर रहे थे तभी, हमको थोड़ी मालूम था कि उसका कितना क्लेम है और उसका क्या
है। भाई वो 10, तुमको ये तो मालूम था कि ये 10 लाख वाला ये देने वाला नहीं मेरे को आगे का फीस।
अरे ऐसा कैसे मालूम? चार्जेस में तो वहाँ 2 करोड़ दिख रहा है, 10 करोड़ दिख रहा है, लेकिन एक्चुअली में तो लोन रीपे हो गया। प्रमोटर बोलता है लोन रीपे हो गया, ये देखो सर्टिफिकेट, अरे सर्टिफिकेट देखो, जब क्लेम आया तो उसका 10 करोड़ का क्लेम आ गया। And now FC is saying you find it out, we will pay not more than 10,000 rupees, 20,000 rupees, and you bring some another RP who is ready to pay. Why I will do this?
This is not my responsibility.
This is not my responsibility. You appoint someone.
नहीं बट सर वो आपको रिप्लेस नहीं करेगा ना, जब
बोलता मैं रिप्लेस नहीं करूंगा, वो यही बोल रहा है, मैं रिप्लेस नहीं करूंगा।
आपने वो
इनको छोड़ना भी नहीं है, पैसे भी लेने हैं, और तुमको ये बोलना है कि वो निकाल नहीं रहा है, जाके बोलो एनसीएलटी को कि सर ये पैसे नहीं दे रहा, मैं नहीं कर रहा हूँ, आप अपॉइंट करो किसी को भी।
अच्छा ऐसा बोल सकते हो?
क्यों नहीं बोल सकते? कोर्ट ऑर्डर में मैंने कंटेम्प्ट का केस फाइल किया है, मैंने कोर्ट ऑर्डर में क्या लिख के दिया था, 5 लाख रुपया देने का है ऑन एडमिशन, उसी ने दिया नहीं। वी हैव फाइल्ड अ केस, वी हैव टोल्ड द बेंच बोल रहा क्या, बोला सर पैसा ही नहीं दिया, क्या काम करेगा, मैं क्यों करेगा, मेरे जेब से डालेगा क्या? दिस इज नॉट अ चैरिटेबल ट्रस्ट।
मेरे केस में हुआ सर, सेम थिंग हैपेंड इन माय केस।
It is you have to speak, you cannot keep on the back seat.
No problem, yeah.
नहीं वो बोलते तुम्हारा काम है, तुमको करना है, हमको फीस के लिए मत।
SBI is there with you, you take from SBI. I said SBI is giving me, but आपका contempt of court हुआ है, I'm just bringing this your notice. वो देर आ गया, कुछ हुआ नहीं उसमें।
अभी आप let us get on to the main topic. What are different ideas for getting details of assets?
This is important.
I think.
हाँ, now the point is.
चालू वहाँ से करेंगे सर, राजेंद्र जी।
Rajesh ji, how to get the information about the asset?
That's the most difficult thing. And we can debate
First for Rajendra ji, before we talk on how to get these details, what is our role to get these things? Are we to do a detective service to get the role, or whatever is produced before us is to be considered?
Not there in individual insolvency. Avoidance transaction is not there in individual insolvency.
It is there.
In bankruptcy, not in individual insolvency.
Bankruptcy.
Not in individual insolvency.
Perfectly correct.
What? Evidence.
So the point is that
yes,
whatever you
individual
get, you
insolvency
prepare
नहीं
the report. If it is resolved, resolution claims are coming in. From that claims, you have to identify, prepare a resolution plan. If it fails.
So 2000
bankruptcy also it is not like in CRP fails liquidation. Here bankruptcy is again the optional. They have to think if they want to take him to bankruptcy, they will go. Finish.
Rather, a financial creditor by filing a PG case, if the person is respectable, he will pay. Otherwise, they are freeing him of all the problems. It is working in reverse way.
Otherwise,
प्रॉब्लम से उसको फ्री कर रहे हैं.
No, सर ने जैसे बताया कि many times PG is just an additional document piece of paper. उसके पास 500 है कि नहीं ये नहीं देख रहे. उसने PG देना है, हमारा चेकलिस्ट है, PG दे दो. वो PG और PG में क्या करेगा? वो आदमी बोलेगा पैसा है तो मैं कहाँ पे डालूं? मेरी बिजनेस में डालूंगा. It is more of moral responsibility on PG rather than. But now it is quantified and put out.
What kind of borrowing he is doing?
और उतना होता तो बोरो ही नहीं करता था ना.
See, even in genuine, non-genuine cases, we forget about it because that diversion would have been done in a planned way.
I don't agree.
So
I don't agree. Let us assume that all cases are genuine.
Yes, I'm keeping that again. Now, when all cases are genuine, I'm only speaking on genuine cases. What happens when the business is in problem? The business is child of a businessman. He will be the first person to put money into business.
Yes.
He will sacrifice his life, he will sacrifice his everyday needs and put money in business because if there is business, he grows. So till the time the business comes to this stage of default, he would have already put everything into his business.
He is not having anything like a substantial amount. So 100 crore loan is there. Maximum he will be able to contribute 2 crore, 5 crore maximum.
नहीं बट सुनील जी का जो क्वेश्चन था दैट इज वेरी इंपॉर्टेंट कि आरपी की रिस्पांसिबिलिटी क्या है टू असर्टेन द एसेट
To put the best efforts. He is a genuine professional. He cannot act as a detective.
No.
Neither he can hire the detective. No one is going to pay.
नहीं बट बेस्ट एफर्ट्स में मींस इज आई थिंक देयर इज सम प्रोविजन ऑफ डिक्लेरेशन फ्रॉम द पीजी नॉट टू टेक ही हैज टू डिक्लेयर कि
He
मेरे
has
पास
to
क्या है.
declare, but statement of affairs has to be prepared by individual insolvency resolution professional.
Based on the information he can gather from FC or whatever resources.
Whatever you get, sir. Detective service and all is to be done by the FC. You don't have to break your head. That's why the things are. It's a simpler task. Your resolution plan to prepare. It's a standardized format will come out. And in that, if he is giving to the FC accepts it, it fell through. If it doesn't, it fails. Finish. There is only one applicant here, the PG himself. No other plans are to be compared. So there is nothing else to be done in this. That is why, what is the role of, look, let's understand individual insolvency is separate altogether, PG is separate altogether. In PG, it's a mode of recovery. Now, once the CRP has failed, then it becomes the mode of recovery for the bank to close that file.
There is no resolution.
So whatever is realizable from that, and in PG, there are people who has given the guarantees and has a substantial asset also. It is like not that he has actually what Satyaji said that everything is given, now there is nothing. That is a very good case. But many cases you will find that the substantial assets are there. Parallelly, the promoter is running the show. In the other companies, other ways, by way of investment, by way of lot of things are there. So to catch hold of that, and that is what is there on papers, you can catch. By detective service, if you even find a hold of the data, that will not help you. This is what bank tells us. You do this, but it is not there. I do surfacey work also. In they say break open the lock. Without the order, I cannot do that. But they say, nahi, tumko paisa chahiye to mula todo, tumko todna hai to. When I went in CRP, when I went for taking custody from the regulator, he said, sir, ye dekho aapko dikha diya na, abhi khol do. Main bola, tu khol, main nahi kholunga. I am taking a video shoot, what you are opening. What the other party says, we don't have to accept. The reason is this process, we are complicated because we started accepting what COC is saying, what regulator is saying. You follow the rule book. If rule book says that you have to do it. Otherwise, don't do it. You go ahead in filing. In a matter, I have gone against the NCLT order to NCLT also. That this order is not as per the rule book. So I have challenged it. So there is nothing to stop you on that. We have made a boundaries in our mind that this is what we need to do. We have to dance to the tunes. I repeat, we are doing that. And there is no need of doing that. We are only 5,000 of the whole lot. And a new circular that has come shows that there is excess supply. That's why the cooling period in exam now has come. If you give an attempt, 2 months cooling will be there after 90 days.
Yes.
So that means there is excess supply. Now the supply is being controlled. So if we 5,000 take this cautious call in taking this profession ahead by doing this, it will all shape up very well. Today they have associations. We have association. We have multiple associations, not one. IBA is the one association for all bankers. IBBI went to IBA to sign a MOU last week.
For COC.
Why? For RPs, there is no one. So I always say that unless these things, what we talk, let's not talk what is being done. Let's talk what is the theory and what is expected of us and how do you do in practical scenario. Otherwise, there is every day we face a lot of grievances. We have a lot of issues in this profession. Still, we are all doing this, no? I am there in 17. Praveen Bhai is there since 17. Devang is there. Hemant Bhai is there. All are, since the start of profession, we are there. So this profession calls for some maturity thinking and maturity to be adopted in execution. Okay. We have gone, like we are all CAs. In CA practice also, we go beyond what is expected from us. And that is where we fall in trouble. Here also, we have started thinking beyond the lines. अरे बाबा बुक में लिखा है ये करने का तो काय के लिए तुम दिमाग लगा रहा है तुम्हारा? Who has called for that additional call? Do what is written. Is there anyone to challenge you? No. But to prove something more and do something better, we are going beyond the things. And this will also lead to the same lines what CA profession is leading to us. I call all us back to this profession that we stick to this book. Stick to the barcode, read barcode and regulation 20 times for the assignment that you do. All things will get clear. There is nothing outside that you want. Jurisprudence, what we say, will get evolved. Okay.
What is difference between CIRP and individual insolvency? Before taking individual insolvency, people should know. Even during CIRP, people should know that there is a fundamental difference in the thought process in which also the both have been made, and in letter and spirit also. Maybe if we go to the Bare Act and go through individual sections, we will be surprised when we are extrapolating some principles of CIRP into individual insolvency, how wrong we are.
So, what Devang says is perfectly correct. You need to follow the principles and if you see in the morning also we had a session where we were discussing on this point only, where lawyers, how they have entered into this profession, law does not, the point that was raised in that meeting, just for the clarity here, I'm sharing that the lawyers nowadays, bench is calling RP ko bulao, liquidator ko bulao, right, for hearing. They don't want lawyers. So the question, that good question that was raised in the meeting, in the earlier meeting, that was that why it is so. When I have appointed lawyer, why I am to waste my time? The pertinent answer to that question was nowhere in the law it is written that lawyer needs to be presented. It is the RP who has to present, and the RP had that onus. You brought the lawyers into picture, and now you are facing the trouble because lawyer brought their theories into play, which were not envisaged in this. This is a law which is a practical law where practical decisions are being taken. And when you bring the lawyers, they start bringing the practical law and matching with civil and criminal laws, and they come out with their theories, and that thesis creates a problem for you. So the law was envisaged with the clear instruction that RP will do all the things. So here also, when we are talking of personal guarantee, don't think too much in lines of CRP. CRP is much bigger concept, much wider concept than personal guarantee. Personal guarantee, you have a limited work to do. Initially, yes, Hemant by point to identify how the person whose personal guarantee you are giving the consent, how nuisance needs to be checked out. That till what level he can go and till what level you can manage. At all front, litigation and any other fronts. But the fear that initially was there in this law, that personal guarantee is going to a personal level and in CRP it is corporate level, that fear should not be now taken ahead except you have not evaluated the person whose guarantee you are working on. If he is someone so-called underworld, then it's a challenge for you if you take his word. But that happens even in CRP.
Yes, sir.
So there is nothing different between that point in choosing. But the process is well defined and it's more or less a formal process where we take the risk is only preparing. We are given the part to prepare the report because we are considered knowledgeable. But that doesn't carry the risk because the plan that is prepared in consultation with the personal guarantor. The plan that is prepared is with the data that he has provided you. The plan, the information that you have is the information gathered from various sources which are also mentioned in your report. So you are not doing anything else but actually collating the data, putting it in a manner which the court says and putting it to the adjudicating authority.
Again, over here when he says I have this assets, I'm making this repayment plan. There are certain exemptions which have been provided by law. Jewelry of so and so amount or jewelry for religious use. If he is having a single dwelling unit up to so much amount, it is exempted.
It is under bankruptcy right now.
Bankruptcy.
When you go for the sale, you have to leave 500 square feet flat or something like that.
But when repayment plan,
I think
whether this should be considered or not considered at the time of repayment plan. So even in repayment plan, this is important.
No, Devang bhai, whatever in repayment plan, if the PG himself is offering everything, then you don't have to say anything. You have to give him the list of excluded assets.
5 minutes में sir, just 5 minutes में we wind up or conclude this topic because this is an unending topic and then we come up with that revised discussion paper which is also a burning topic.
So is this
your question?
Or either we choose, either we continue this topic or we want, but that is also important.
Paper I think we should discuss because that representation is required and it is this topic we can conclude in 5 minutes. So Ashish, your question you can.
So only one question.
Individual bankruptcy का किस करके रखते हैं पुलिस वाला मैटर ज्यादा इम्पोर्टेंट है डायरेक्टली हिट होता है ऐसा ही ज्यादा जरूरी.
So is this mean that if you identify any other asset and the corporate debtor doesn't agree, then he will not include that in the resolution in the payment plan, which will reject and he will go to bankruptcy court.
Yes.
So rejection कुछ फायदा
He
नहीं
will not go. Even that is not automatic over here. It may trigger, it may not trigger.
90% cases, believe me, will get wind up in 60 days. क्योंकि वो resolution 30 days में plan देते हो, fail हो जाता है, फिर कुछ काम ही नहीं है, खत्म गेम. तुमको सीआरपी में प्रोसेस चलाना है कंपनी का, इसमें कोई कंप्लायंस ही नहीं है तुम्हारे पास.
यहाँ पे वो प्लान दे रहा है और
इट इज नॉट द कंप्लायंस टू बी डन ऑफ दैट. उसका सब पुराना रिटर्न बाकी है, फाइल करो. सो व्हाट इज द वर्क इज ओनली 2 reports, 1 this and then resolution plan and final report finish.
Repayment plan, actually some of the clients are outsourcing to us. We have prepared number of repayment plans.
सर ऐसा कौन सा काम है इंश्योरेंस का जो आप नहीं करते हो?
तो करना ही पड़ता है ना सर. अभी एक ही बुफे काउंटर पे खाने का तो खाना ही पड़ता है ना सब कुछ. उसमें भी चॉइस रखेंगे तो कैसे होएगा?
पर्सनल गारंटर का अदर बिजनेस भी तो हो सकता है ना,
सब बट वो डिस्क्लोज करना पड़ेगा ना.
वो खुद को बताना चाहिए ना. प्लान
यस टू टेल मी
इंटीरियर मोरेटोरियम उसको भी लग गया ना.
हाँ सबको मोरेटोरियम मतलब उसको पर्सनल लेवल पे सब लिटिगेशन अगेंस्ट हिम गेट स्टेट.
180 days का टाइम स्टार्ट होता है, कब से होता है?
फ्रॉम फाइनल एडमिशन.
ऑर्डर
मोनिटोरियम जब से स्टार्ट होता है, इंटरिम मोनिटोरियम से नहीं.
इंटरिम नहीं,
फाइनल ऑर्डर मोनिटोरियम जब से स्टार्ट होता है. I think we conclude this, otherwise this is ongoing. We can take a whole topic on this in some other day where we can take step by steps learning process, because what we feel is that most of us have not worked on the transaction, so that theory needs to be repressed. What at the start of session we thought that we need not go through that, but I think we need a look on that, revision session on that to be done. Maybe either by this group study or the group can initiate with WRC to have an individual insolvency session, 3 hours session, which can run through the whole process. Let's do that way. That would be much better. This group, let's discuss the.
See, WRC, if it is not a study group, then it will be a mono talk. Then it will not enjoy.
So
what the advantage of study group is that interaction and question answer and cross question and different people's view.
It's the same topic. If I have to give, I will prepare the PPT. Brush out 5 मिनट में क्वेश्चन आंसर कुछ हुआ तो ठीक है, अदरवाइज खत्म. इधर तो क्या है कि कोई भी स्पीकर आएगा तो उसको तो क्वेश्चन करके उसको सब्जेक्ट सिखा देंगे पूरा.
और अपना ये डिस्कशन के बाद हो सकता है कुछ लोग माइंड चेंज करें कि they will also adopt the.
एक और चीज है कि यहाँ पे अपने जो स्टडी ग्रुप है उसमें सब लोग डिस्कस करते हैं, आपस में सवाल पूछते हैं तो कुछ समझ में आता है. अदरवाइज क्या एक आदमी ने बोल दिया और जो बोला वो सुना.
एक सिंपल सा क्वेश्चन है, जिसने नहीं लिया क्यों नहीं लिया, अगर वो समझा सकते हैं हमको तो वी कैन हेल्प यू आउट. जो कोई लेना चाहता है पर 2 स्टेप पीछे हट गया कि हमको लेना नहीं है, और वो उसकी क्वेरी दे सकता है तो वी कैन सिट हियर एंड रिजॉल्व, बिकॉज देयर इज नथिंग डिफिकल्ट. जिसने नहीं लिया और लेने का मन है, जैसे आपने बोला ये होगा वो होगा, तो आप क्यों नहीं लेना चाहते? एक तो मॉनिटरी कंसिडरेशन है, और छोड़ के
नहीं रिस्पॉन्सिबिलिटी का कोई टेंशन नहीं, रिस्पॉन्सिबिलिटी तो ले सकते हैं. बस सेकंड क्वेश्चन व्हिच दे हैव टोल्ड.
डीलिंग विद इंडिविजुअल्स आर डिफिकल्ट.
So you are right, perfectly right.
इमोशनल थिंग क्या होएगा, इंडिविजुअल इंसॉल्वेंसी के स्टेज पे नहीं आएगी वो प्रॉब्लम, बट बैंक्रप्सी बन जाती है.
प्रिसाइसली तभी, क्योंकि एसेट बेचना इज
बहुत प्रॉब्लम्स आने वाली है.
मनोज भाई, काला कोट तभी आएगा बीच में, आप टेंशन मत लो. आज के डेट में भी आप कुछ भी इनिशिएट करो तो पीजी कभी रिप्लाई नहीं देगा, उसका एडवोकेट ही तुमको रिप्लाई देता है. बराबर है, तो एडवोकेट टू एडवोकेट ही चलना है आपको. सिर्फ आपका सॉरी
एसेट अपने कंट्रोल में लेने होते हैं.
हाँ, तो वही मैं बोल रहा हूँ, वो सब एडवोकेट टू एडवोकेट चलेगा.
कॉर्पोरेट ऑफिस जाकर के कंट्रोल में लेते हैं ना, वहां तक तो ठीक होता है.
पर्सनल कैसे,
पर जब किसी का रेजिडेंशियल घर में जाकर के कंट्रोल लेना होता है ना, तो दैट बिकम्स वेरी डिफिकल्ट.
फर्स्ट स्टेप कीजिए ना, फर्स्ट स्टेप तो करो, ये फर्स्ट स्टेप तो मोटिवेट होकर कीजिए, सेकंड पे मत जाइए.
फर्स्ट स्टेप घर पे कंट्रोल. मेरे केस का रीपेमेंट प्लान बनाया तो वो बोला घर पे कम से कम 5 लाख रुपए का वो होगा नहीं, आपको उसकी गाड़ी तो बोला, मैं बोला ये तो पर्सनल इफेक्ट है ना, वो तो एग्जाम है.
एक गाड़ी ऐसा है, एक गाड़ी ऐसा है,
I think sir, we will have a special session on this. This was just an introductory session.
20 लाख रुपए
हर महीने में एक बार मिलते हैं हम लोग,
हर महीने में मिलते हैं और कोशिश करेंगे तो ज्यादा भी मिलते हैं.
विराट में तो नहीं रहते.
जब ज्यादा भी मिल सकते हैं.
व्हाट्सएप ग्रुप तो है,
व्हाट्सएप ग्रुप एक महीने में एक बार मिल सकते हैं. फिर
डोंट आस्क फॉर ये जो इधर जो मिलने का मजा है ना, ऑनलाइन नहीं.
सर एक मुझे लास्ट 2 मिनट दे दीजिए प्लीज. गिव मी 2-3 मिनट्स, 5 मिनट चलो. थैंक यू. My questions are very simple. You know, when I already published the advertisement, I used to receive the claims. Okay. Now there were certain claims which I have received that I have given the money to HUF of that particular individual, and furthermore I have received as a partner in capacity of partner also. So now you can give one by one of your opinion, because I want more opinion on this. How to deal with this situation? HUF को पैसा दिया है,
जो से क्लेम आया और एज ए पार्टनर क्लेम आया.
Then there can be the liability.
Precisely, these are separate individual entities.
He is not करता that. No. My understanding is HUF के केस में liability personal नहीं आएगी. It is the liability of the HUF.
करता.
केस of partnership.
वो personal आ सकती है. Yes, partnership is personal.
Individual partner
is talking on the different thing.
Liable. तो पार्टनरशिप की अगर कोई लायबिलिटी है, डिफॉल्ट है,
क्लेम है,
एडमिटेड इफ देयर इज एनी क्लेम,
HUF का है तो नहीं करना चाहिए.
मेरे हिसाब से HUF की भी आएगी. क्यों आएगी कि इक्वल मेंबर से HUF में 4 मेंबर है, उसका पोर्शन 25% का, तो 25% की लायबिलिटी आएगी. क्लियर कट है.
सर HUF का शेयर आपने कैसे डिसाइड किया?
जैसे आपके घर में आपके 2 बच्चे हैं, 2 लड़के हैं, एक लड़की है, 3 बच्चे हो गए, एक वाइफ को नहीं मान लेंगे.
लेकिन किस मेंबर का कितना शेयर आपने कैसे डिसाइड कर लिया? आईपी कैसे डिसाइड करेगा?
नहीं आईपी 5 जन मेंबर तो 5
नहीं 4 शेयर आप कैसे? इट इज एज पर लॉ, इट इज फैमिली डिविजन, इट इज फैमिली प्रॉपर्टी, it is family which has to decide.
No.
Yes, family will decide 1% only to that person.
स्ट्रक्चर में नहीं है, ऐसा नहीं है. आपका इक्वल
करता है नॉट द
आपका इक्वल पार्टीशन है, आपको इक्वल देना पड़ेगा सर।
नहीं सर, इक्वालिटी इज नॉट द कंसेप्ट इन HUF, इट इज इंटरनल फैमिली डिवीजन
है, हम आपको दिखा दूंगा, हम आपका आएगा डिसीजन में।
एक मिनट आप इतना पसंद लो सॉरी बेचारे बोलो अरे आप बड़ी दवा छिले तुम्हारे ओपिनियन लिए
मैं आपको दिखा दूंगा, इसमें लिखा हुआ है।
अच्छा दूसरा कोई ओपिनियन because this is burning problem I am facing. I have to admit the claim. वो बंदा बोलता है तुम मुझे क्लेम नहीं देगा तब तक मैं रिपेमेंट प्लान कैसे बनाऊंगा?
क्लेम आया ना,
क्लेम तो अलग चीज हो गया।
अरे भाई जिसको ऑब्जेक्शन लेना वो ऐसा ही लेगा ना कि तुम मुझे क्लेम नहीं देगा तो मैं रिपेमेंट प्लान कैसे बनाएगा?
Can this Karta who is a PG, assuming that this person is a PG, can he divert the HUF assets for repayment plan?
Precisely. If he can, then it should be liability. नहीं ये तो मत करो.
Sir, first of all, check whether this applicability is applicable to HUF or not. If is personal guarantee applicable to HUF?
No, but then once the guarantee is there, then any claim can come. Now, why only personal guarantee claim will come? Suppose Mr. A is there, then he has given the money, that claim also will come.
Sir, HUF का liability is it the liability of individual or a liability of HUF?
HUF का liability
खत्म हो गया ना, तो एसेट भी HUF का एसेट है, फिर यहाँ पे कहाँ से आएगा?
HUF में ये
What is rightly said, sir? If it asset is not there, why it should be taken?
It should be different person.
Second
Yeah, it should not
thing,
be
partnership definitely it can come. Every partner is having unlimited liability and joint and several liability. Matter finishes.
पार्टनरशिप को कौन नहीं आना है?
पार्टनरशिप का तो कंफर्म है. I think we are all agreeing on
Sir,
that.
in HUF case, what is the liability of the co-partner? In HUF, 4 people are there.
To the extent of asset of the.
Sir, he is of the opinion there are two different schools of thought. I am of very clear opinion that it is.
Of law, one law is applicable for certain states only. That Kolkata and all, 2 states only. The rest of the states, the liability is crystallized only to the Karta, not to the co-partners.
वो उसमें दया भागा में
Daya
भागा दो है
So he is 100% responsible, and because he is taking the active part in the business, he is taking the active decisions also.
Anyone has to say anything else?
But what to what extent? Percentage?
100%.
Okay. Any other opinion? Sir, what is your opinion?
Sir, in HUF, basically, the point is very clear. In HUF, which school it belongs to, accordingly you have to go. You cannot opine. And for that, as a RP, if I have to take, I will take a legal opinion. I will not apply my mind in going into the intricacies of the law, where the law is not clear on the point. This is a question of law that is being raised. To take a legal opinion, based on the legal opinion, accept the claim. And if you still want a direction, go to the take a direction with the legal opinion that this is a legal opinion, but this is a question of law. So it has been raised to your lordship. Finish.
Second, small disclaimer, sir. Everything that has been discussed over here is opinion of every individual, not opinion of any institute or any organization. Second, it is only on the limited points which it is only for academic reasons and limited points. When the facts of the case are seen or the situation is seen, only at that time detailed opinion can come in, and the opinion expressed over here by any individual sitting over here may change. Is a personal opinion, may even change in different circumstances with different facts.
It is always
we are not qualified lawyers and accept.
It is always taken as granted. It is needless to say, you know. आपके हिसाब से आपका सर लॉ के मतलब beyond that, what is your opinion? मतलब on this, no doubt, I agree that legal opinion has to be taken on this.
Sir. So basically, when HUF claim, some of the HUF comes, and if it has to be liability has to sustain, it will sustain. Now, what is the amount that has to sustain? Like 25%, what we say. Like in one school, you cannot divide till the division takes place. So till that time, everyone is equal. In another school, it is pre-decided on the division part. So that's a key good question here, that in this thing, how do you take it in HUF? So you need to know which school it belongs. So each school is recognized with the place where it starts from. The ancestral thing starts from. So if it's a south base, it has their own school of thoughts on HUF. If it is a west base, it has its own school of thought in this. So based on that, you will have to go to Hindu Succession Act to see that, and then admit the claim if you want to really understand that part.
I differ on that.
Sir, in fact, I even give you the date, sir.
As far as Devang school is concerned, no one except the Karta is having the 100% rights. Only at the death of the Karta, the other is getting the right. As far as Mitakshara, at the time of birth itself, you get the equal share. But this is not related to the share. As far as our understanding, my and Rajendra ji's understanding is concerned, Karta, if HUF is doing any business, and if that business is having any liability, the liability of the Karta is unlimited. Just like partnership, there is a correction I had said that HUF ka nahi hoga, but the liability of HUF is unlimited as far as the business done by HUF. So co-partners are not responsible. It is not related to their share in the HUF, but it is whether he is a Karta or not. If he is a Karta and the liability is taken by him to the HUF, then he is responsible.
I have one case of under the old insolvency law where this kind of situation has arisen and court has directed the person to launch the claim as an against individual against for HUF, and that case law is there, but it is under old insolvency code.
But that applies, the ratio applies here also.
Yeah. So that I think
liability of Karta has been taken as that he is a agency business of HUF, just like in partnership, every partner is an agent. So Karta is taken as an agent of HUF, doing business for it.
It is available on Google. You can just click it and you can get the judgment. But it is still available. I'll put it up. No issue.
WhatsApp group में डाल दो ना.
मैं डाल दूँगा because अभी I came from.
आज नहीं कल डाल दो. परसों डाल दो. Monday डाल दो.
Fine. I think we can go for another topic.
So first of all,
you can introduce the circular, sir.
Sir, एक minute. So first of all, thanks to all these three speakers, three group leaders, Mr. Kirav, Mr. Devang, and Mr. Hemant.
We are only group leader, not speaker, please. Everyone is speaker.
We are also contributing equally.
At a very short notice, within 2 days' time, they have agreed and they have come and taken us through the various intricacies. And we hope they will have a second session on the same topic.
He also would request other members to take this initiative to become a group leader to take this lead, so that this group takes a different shape over a period.
Yes.
Regularly, me, Praveen Bhai have been speaking, Hemant Bhai, Devang, but we want other people also to come up now and take the responsibility to run this show.
And it is very enjoying, very much enjoying.
It's apart from enjoying, it is very interesting because for these things one has to prepare. And seminar चल जाता है. इधर तो जैसे बोला ना कि उसको सिखाएंगे, इधर वो सिखाई होती है. So you will learn also, and there will be no embarrassment because everyone is learning in this group. So there is nothing that someone is raising this question and I don't know and I'm taken the lead today. But be open to take this lead. This will help you to understand the subject much better way. This will help us to grow this study group in a bigger way, and it will also give a depth of knowledge on the subject.
And you will be able to face the COC much better if you take the leadership.
COC also NCLT.
NCLT.
I have become a lawyer more by compulsion rather than choice, but I am enjoying it now. जब पैसा नहीं आता है तो अपने पास choice ही नहीं होता है. I do not have the liberty to take an opinion of another person. So read the book, take an opinion, go to the bench. अभी सर बोल रहे हैं भाई lawyers are appointed. मेरे पास lawyer का पैसा ही नहीं देने के लिए तो करूँ क्या? It is more of compulsion, but I am enjoying it now. एक स्टेज ऐसा आएगा, you create a reputation of your own. In fact, IP should represent. आप अपना एक लेवल बनाओ जहाँ पे lawyers आपको डिफरेंट, I mean, I'm not against a lawyer or anybody, but you can equally be or better than them. जो हम कर रहे हो. और ये हमारा प्रोफेशन है.
Don'ts of tribunal needs to be learned before you appear. Be very clear. Don't think that I am a chartered accountant, I am a IP, I have all the things at my armory to appear there. You need to know very specifics, what you need to say, how to present yourself. Learn that and appear. Without learning, I request don't appear. Otherwise, it will backfire very badly.
But do it. I mean, it's not difficult.
I appear, Kirav appears, Praveen appears. We are all regularly appearing.
She was 24. We had filed against one very large company.
Admitted, sir.
And today it is admitted.
2 days back.
Two days back it has been admitted. And we recovered 99% of the money and the client was very happy. And the bench member used to ask my daughter, who are you? I am practicing chartered accountant. And 99% of the chartered accountants don't know that they are eligible to appear at the NCLT.
Precisely. They are able to appear at tribunal and the tribunal respects you. When I approach NCLT also I found नहीं करता है, ऐसा नहीं करता है.
तुम्हारे सामने जुडिशरी वाला खड़ा रहेगा तो तुमको नहीं पता.
नहीं कुछ नहीं सर, ऐसा कुछ नहीं. जैसे ये बोल रहा है सर, एक 30 करोड़ का लाइबिलिटी में 150 करोड़ 1.5 crores I have recovered in NCLT matters only, and that was my first case. वहाँ पे 5 जाने हम अकेले. How I do not say it is applicable. कर सकते हैं सर, और करने के बाद में रिजल्ट भी आता है.
Come back to our discussion paper.
तो पूछने के लिए ताकत होनी चाहिए ना. जब पूछते हैं तब
आपको जवाब देने की ताकत होनी चाहिए.
हाँ, वो तो होनी चाहिए. जब आप पूरी कंपनी मैनेज कर सकते हो, जब आप पूरी कंपनी मैनेज कर सकते हो,
मन करता है कि इतने इंटेलेक्चुअल दिखते हो, पूछो नहीं तो क्या करूं सर.
नहीं, जब आप पूरी कंपनी रन कर सकते हो तो क्वेश्चन तो कंपनी में से ही पूछने वाला है ना. आपने जो किया उसी से पूछ रहे हैं. अगर आप केस भी डिफेंड कर रहे हो तो लॉयर भी क्या करता है, वही डिफेंड कर रहा है. तो हम क्यों नहीं कर सकते? हम तो बहुत अच्छी तरह से कर सकते हैं. इनफैक्ट एडीआर प्रोफेशन जो अपना है, वी शुड इनफैक्ट इंसिस्ट के इसके साथ में नेक्स्ट प्रोसेस इन आईबीसी इज एडीआर कंबाइंड विद. तो अब एडीआर के साथ मेरे को आधा से ऊपर तो रेजोल्यूशन पहले ही होने वाला है, आएगा ही नहीं एनसीएलटी के पास. एडीआर के थ्रू जाएगा.
डिस्कशन पेपर आया, फिर आगे में चला गया.
वो तो
चलो. Just to give introduction, the fees issues have been discussed at various forums. Actually, at all meetings also, wherever we have gone, the fees is always discussed. Ahmedabad, Jaipur, Bombay, Hyderabad, everywhere this topic is always discussed, whether in meeting or outside the meeting. Well, we have a tea and coffee. So now the IBBI has come out with the discussion paper. It is not the law yet, but then we are required to give our thought process on this so that they are taken well into consideration before it becomes the law. Otherwise, after it becomes the law, we say, ye nahi kiya, wo nahi kiya, we keep blaming each other, will not help, or we keep grudging ourselves, कि एक ऐसा law बना दिया. So this paper has come just 2 days back. I think most of you must have read it, otherwise ये screen पे डाल दो.
Screen पे डाल दीजिए तो अच्छा होगा. Point wise.
Majority of them must have read it. Fees के बारे में तो सबको पढ़ लिया है. Definitely interest रहता ही है.
स्क्रीन पे नहीं आएगा सर.
सबने पढ़ लिया. 2-3 points need to discuss in this.
One of the bases is that on the basis of various case laws, where this NCLT has asked the IBBI to fix some guideline. And on that basis, the IBBI has come out with this as a guideline or as a discussion paper. So one of the first and foremost thing which I find is that they fix and everything may be fixed, but whether there is a responsibility cast to pay on month-to-month basis. That is very important.
एक बात सर, IBBI या जो भी रहता है, इवन NCLT भी बोलता है, जैसे उन्होंने बोला पेमेंट इज समथिंग डिफरेंट एंड फी समथिंग. इनको 5 लाख का दिया है, वो पे ही नहीं कर रहा है तो क्या करें? एंड दिस इज द प्रैक्टिकल डिफिकल्टी. नहीं देते हैं लोग.
Operational creditor or a small financial creditor not paying is one thing, but suppose a large bank or large ARC, if it is not paying,
100 करोड़ का क्लेम में नहीं आ रहा है. सर
मेरे केस में
100 करोड़ का क्लेम में नहीं आ रहा है तो क्या करें?
80% is financial creditors and other financial creditors are 20%. 80% is saying कि I will pay. 20% is saying सर हमारा तो छोटा है, जब पैसा मिलेगा तब देखेंगे. So what we need to know?
Whether the secured financial creditor only to pay or unsecured financial creditor also to pay.
जो सी मेंबर जो होगा वैसे ही देगा ना.
Sir, but unsecured creditor is sure that he will not get anything.
The unsecured financial
become a part of COC, he has to pay.
He has to pay.
There is a judicial pronouncement which says that if you filed a claim and you don't want to pay, RBI has been asked to reject his claim.
That is what I am going to plan precisely. I have the case law. I am going to plan.
Reliance Commercial Finance.
You have to reject the claim.
If he is not ready to pay, you can reject his claim.
And if the secured financial
Particular case, it is not a landmark judgment to be applied in all matters.
Because in my case, 80% is saying I will pay, but I will pay only 80%.
ले लेना 80 तो ले ले यार रेगुलर हो
अरे तो 20% वाला
बाद में केस फाइल करना वो 80% से पैसा आएगा उस पे 20 पे केस फाइल
होगा तो ही मिल जाएगा ना
पैसे को कैश फ्लो को आगे बढ़ाओ हम तो ऐसे ही कर रहे हैं जब पैसे चला दे आपने 80% मेरा तो 70% है 30% नहीं दे रहा है
हमारे एक मैटर में वो बोलता है मैं 20% फी पे करूंगा आपने जो क्लेम किया है उसका whereas it is ratified 20 बोला 20 पे करेगा पे करने के बाद उसको लेटर भेजा अभी मैंने लीगल बैलेंस 80 दे बोलता है हमने तो बोला था 20 मैं बोला 20 देने का बोला था मैंने ले लिया 80 तूने रेटिफाई किया वो दे अभी मैंने ऐसा नहीं बोला था मैं 80 वेवर कर रहा हूं तो 20 दे रहा है तो प्रोड्यूस डॉक्यूमेंट दैट इज नॉट देयर मिनट क्लियरली स्टेट्स दैट 20% ही इज पेइंग आई सेड आई विल मिनट व्हाट यू आर सेइंग तो खुश हो गया 20% लेके एक्सेप्ट कर रहा है मैंने मिनिटाइज किया दैट दे हैव एग्रीड टू पे 20% नाउ बस फुल स्टॉप 80% बोला ही नहीं मैंने देखो वो खेलते हैं तो तुमको भी खेलना आना चाहिए प्रोफेशन में इट इज लाइक यू हैव टू प्ले अराउंड इफ दे प्ले मिस्chief you play mischief but play within the boundaries
yes very right
Okay, so let's come to the core subject.
अगर हो सके तो स्क्रीन पे अगर डाल सकते हो तो
नहीं होगा सर वो चालू है ना
someone can lead it possible
someone can lead it see there are the first of all there are the various decisions from which IBB have taken the lead now the statement of problem they have given that there are the various regulations which says that the fees is there 513 is the CRP cost unlike fees for the liquidator the fees has been laid down but I have come to know that the banks are also negotiating on that also if there are large size asset bank is saying that the table will not apply people are saying that 50% of table 20% of table all that is happening I don't know I am not aware of no you are right it is there it is
in one of my matter I am an RP and liquidation application is filed so they wanted to negotiate the fees table ke niche and that too will be paid at the end
yes
I refuse I am not interested in becoming a liquidator
yes
so sir that section if you go to that table no so clause A says as decided by COC
yes
and if that is not decided then the table applies
yes.
so they are using that clause to that it is up to you if you negotiate with them you accept that fees or you take the table
yes
but it is not mandatory to take table but one point that is this being not considered in this is RP to liquidator they are filing change of liquidator application
yes.
that is there is no provision to change the liquidator yes. RP continues to be a liquidator
yes that I have favorable decision in my favor but now subsequently I said they want to change it I said okay I also want to get out of it
Sir, you share the decision that has come where it is because I could not find in that decision no decision I could find where this change was objected by NCLT and given in the favor of the RP
I said they want to change it I am also willing to come out
so that is a different story I say I am RP I am willing to work as a liquidator okay and they say that no we want to change the liquidator they have no right to change it
they have no right to change that is in my case we have argued and we have appointed but then subsequently after 1 year I said if you want to change I am ready to go out
so order set
yes
so moving ahead back to point
there is no restriction on NCLT they can change it if they want they may not NCLT
where under which provision they can change they are arbitrarily using these things they don't have that power they can change only under
it is written that NCLT adjudicating authority may appoint RP as liquidator
no main word nahi hai
main है
no RP will be appointed as a liquidator
नहीं है
word है मेरे केस में हुआ है और क्या हुआ था उसने मुझे अपॉइंट कर दिया था मगर बस गलती से किसी और का नाम डाल दिया ऑर्डर में and then next day when I said
Section 34
in the order they said no you don't have a vested right to be appointed as liquidator it is NCLT they read the provision they said that it is written may and they may change it it is, then what is the use of, then what is the power of NCLT?
Manoj
They
bhai.
can change it and we have changed it.
Manoj bhai, there are only 4 sections under which they can change, and in that this is not there. They have a right to change. But this is not there. But
Generally it is not done. But
let's come to this subject. We'll take this offline. Otherwise, we are running out of time. We'll not be able to cover this.
Under General Process Act, may word to be considered as a shall. So,
not always.
Only in cases of public interest. So it will be interpreted as a shall, not to may. Though it is written as a may.
There is no vested right as per them. There is no vested right of RP to be appointed as.
But COC is original
You are the officer of the court. I change the officer. File में जो एक से दूसरे के पास जाती है. So court always have right.
अभी जैसे COC passed the resolution. What is happened in COC passed for the liquidation.
COC ने अगर पास किया है तो NCLT के पास वो राइट नहीं है अगर आपके अगेंस्ट में कोई कंप्लेंट नहीं चल रहा है LBBA का. आप NCLT के अगेंस्ट में एनक्लेट में जा सकते हैं.
But then second, if the resolution plan fails because of some problem, then only they have a right.
They have a right.
But if the resolution plan is once passed, that is over. Then there is an earlier circular also of January 16, 2018 about the fees. That is there.
कंटेंट ही ले लीजिए ना सर. कंटेंट में जो लिखा है ना कंटेंट 1.5 लाख में जो लिखा है ना कंटेंट.
हाँ कंटेंट में लेके जाते हैं कि now what they are supposed to do is they are saying that कि there will be component of the fee. One is a fixed fee structure.
1 minute before you go to the content, in the statement of problem, okay, the 8th point is read as, however, the board has through IBBI, Insolvency Professional Regulation 2016.
जब आपका वो कुर्सी है ना वो स्क्रीन को ये करता है, स्क्रीन शेयर हट जाता है.
IB regulation and circulars provided guidance in the matter of fixation of remuneration of IP and other professional appointed by him. Full stop. Then it says it broadly provides that the fees and cost charged by IP must be transparent and a reasonable reflection of work necessarily and properly undertaken. Let's understand this. Reasonable reflection of work necessarily and properly undertaken. Okay, just keep this point while going further because this will be a part of the discussion when you go ahead on the things. Yes.
What is expected that the market will determine, but then in particular cases it has been observed that A is often burdened with this issue. बहुत टाइम A के पास ये केस चले जाते हैं कि fees is not proper or fees is not paid or whatever it is, so they have said that such a situation is undesirable but yet avoidable. If some benchmark is set up, then it will be better. If the IB is fully closed, fully available, they can do it. Now the fees they have break up into 3 components. Basically, to fixed fee structure, per month fixed fee, whatever we are talking about, and second is the performance linked incentive. There are 2 types of incentive they are talking about. One is for the timely resolution, and the second is for the value maximization. Now, value maximization, my one single observation is that okay, we go having a third is issue 2. Issue 2 is having an escrow mechanism for payment of fees to the IP. So this is very important because what happens in many cases we have seen that still for 1 year, 1.5 year, 2 years, not only the fees are paid, but then the whatever expenses which are incurred by RP for appointment of valuer, auditor, liquidity, valuer, transaction auditor, they are also not paid. I had one case where they had not paid fees for all of this expense reimbursed for 20 months. And I used to get regular phone call from the valuer, transaction auditor, lawyer, what happened to my fees, what happened to my fees? I said, I have not got anything, it is your lookout. So it becomes a very difficult situation. So now at least they have come said having an escrow mechanism and this should be very firmly done. Yes, sir.
On this escrow mechanism, presently also when the CRP gets ended and liquidation starts, the provision is there that liquidation plan be made and CRP cost be deposited in 30 days. But it is not implemented. practically. So this escrow, unless strongly implemented, will be a challenge.
On paper.
In this fee structure, what they have done is one thing that we also take positively is they have given us a benchmark. Our value, lowest value for IP is 1 lakh rupees, 1.5 lakh rupees per month. 25,000, 20,000 wale should leave the profession. This is what regulator tells by this discussion paper. Minimum fee is 1.5, but compared 1.5 per month is the fee, but it is compared with the quantum of claim is something not understood by me.
There are other factors also, whether the unit is working, not working. That is totally disregarded.
No, there may be claims is something cannot be linked with the fees.
No,
but this is the minimum thing.
That thought process may be there. ये पैसा कौन देगा? क्रेडिटर ही देगा. तो जितना क्लेम आया उसी हिसाब से देगा. पर क्लेम के अंदर फाइनेंशियल क्रेडिटर ही दे रहा है. बाकी सब कोई नहीं.
But this is a minimum, which the good thing is that is the minimum they have stated.
It can be higher than this.
It can be higher also. And if the unit is working, then it needs to be higher. Then
that is what we need to add here. If the unit is working,
then it needs to be higher. Second thing, sometimes we find that the company is working, but the most of the staff have left. So it becomes very difficult to manage. That all points are
what we propose.
Here on this fixed fee, basically, if you go further in this circular, they have given ICAI, cost CAS, cost accountant, and advocate. Three institutes, they have said minimum recommended fees. This should be and here they have not said that it is minimum recommended fees. This is minimum fees. There is a difference between both.
Not recommended.
It is not recommended. This is minimum fees. So a baseline is given. You can negotiate as per your capability.
But this is a minimum.
This is minimum. But the point is, it is compared to quantum. Now, quantum of claims admitted, not quantum of claims collated. Quantum of claims admitted. Now, do you, as the RP, do you want this fixed fee? Yes, fixed fee, welcome step. But do you want this to be linked with the quantum of claim is the point that we have to write. 30th June is the last date to write to IBBI. And they have a standard format. You don't have any other options. So if you have a specific comment, you write. If you have general comments, they have subclauses. You choose the subclause and go ahead. So whatever is decided, all IPs should make it a point that they go and post that. Don't only think that the ICAI will do or this person will do, this association will do. Don't rely on any association. Individual IP should get their login and pass their comments. If that comments accumulate and they are substantial, it will work out. Otherwise, already they have sent the draft with the June date. So that means as soon as the 30th June gets over, they are going to issue this notification. It is already June 22, just the date is fill in the blanks. So be ready. If you are not able to push this, then this will become the reality and then don't cry. Because this is the only part which is a very good part in the whole circular where 1.5 is kept as a base in my view. Other all are lollipops.
One of the difficulty which I noticed is that in large maximum amount they have kept is only 7.5 lakhs.
That is minimum.
That is minimum. And at the top level also they have kept only minimum amount 7.5 lakhs.
So you negotiate, no? If
negotiate,
the case is high,
because what happens if you are running a large case, you need around 4 assistants. So they itself cost you around 2.5 to 3 lakhs. Minimum 3.5 lakhs.
I think this is talking about RP's fees.
RP's basically.
Whether does it include the process cost or processor advisor cost?
No. Processor advisor, I think it is included now. Otherwise, if you say, okay, if I get a case of 50 crore rupees and I say I will engage a IPE, who will charge again there? The bank is not going to accept.
They have taken this charge. There in this it is mentioned that one of the large bank was none other than SBI, and our circular is printed as it is given by SBI to them.
Right.
Okay.
So does it include the again I will tell you.
So this is only IP fees, no IP, no support, nothing.
No, that's right.
That is what the circular is. The IBA which has signed MOU with IBBI is for implementation of this. So tomorrow, if once anyone bank says that I will pay 1,40,000 only, then they will be taken reprimanded for that. That is the idea in bringing this circular.
But
so
that
positivity of this circular is
this
that
is all inclusive, na?
per month your professional fees.
But then IP and IPE both inclusive, na?
IPE नहीं है सर.
तुम्हारे को स्प्लिट करने का तुम रखोगे तो
तुम ऑफिशियली आईपीई को साथ में ला रहे हो या तुम्हारा फीस में आईपीई को देने वाले हो. अगर तुम्हारे फीस से आईपीई को देने वाले हो तो आ गया. तुम सेपरेटली उसका अपॉइंटमेंट करवा रहे हो कि ये सपोर्ट सर्विस प्रोवाइडर है, मेरा 1.5 लाख और उसका 5 लाख, तो अलग है.
तो वो अगर बैंक एग्री करेगी तो नहीं तो तुम्हारे भी इसमें से दो.
तुम्हारे इसमें से तो ये मिनिमम है. अभी तुम नेगोशिएट करो. तुमको कम लग रहा है, नेगोशिएट करके ज्यादा ले लो.
आपके सबसे बिग केसेस है जैसे आप हैंडल कर रहे हैं या वो हैंडल कर रहे हैं.
मेरे पास बिग नहीं है, सब छोटे
ऐसे ही मतलब एनी हाउ बट यू नो तो उसमें आप यू विल से कि भाई आई विल रिक्वायर एडवाइजर एंड आई नीड टू अपॉइंट.
हां लेकिन वो
करते हैं ना बैंक वाले आईपी फॉर्म देने के लिए.
जो सर ये मिनिमम वर्ड लगाने के बाद में अपर साइड में आप जितना नेगोशिएट कर सको आज कर सकते हो, बाद में करो, कोई दिक्कत नहीं. लेकिन जो मिनिमम वर्ड लगा दिया तो वो 50,000 1 लाख वाले 25,000 वाले वो सब जो है छट गए.
सर उन्होंने अभी क्या किया है, एबीसी एनालिसिस किया. पहले वो जो 30-12 गया, अभी 2,500 के ऊपर वाले दिख रहे हैं कितने हैं. तो एबीसी एनालिसिस में अभी टॉप का टैपर खत्म हो गया है, अभी जो है नीचे वाला है, तो उसमें मिनिमम कर दो. बट दैट इज इटसेल्फ दैट थिंकिंग प्रोसेस इज रॉन्ग. IBC talks of default, not of NPA. The day it went into SME1 and if they start filing the case, lot of things will improve. They wait till NPA and NPA happens. Once the actual NPA happens, then evergreening happens, then official notified NPA comes out.
And before NPA comes, management of NPA happens.
That is at the bank, na?
So practically,
separate branches for them, na?
So practically, when why I said that the previous line which I read, reasonable reflection of work. Now this means the claim verification is a reasonable reflection of work according to that, because claim is quantified with your fees, which is not so. Practically, it has to be minimum fees per month this much, and then per man hour of the qualified people. Probably that could be an ideal way to look into qualified, non-qualified. Expert person on the work, man hours calculate karo, budget banao aur do. That would have been an ideal thing where these things can go up.
Then see that it is difficult na. How many assistants you are giving and how many are working for this assignment?
Institute circular of minimum fees also. In the institute circular of minimum fees, number of it is based on the number of hours only.
Sir, all professionals.
But then here in the monthly assignment, you are handling 3 assignments, somebody is handling 4 assignments,
Sir,
some has 3 assignments.
I have to calculate number of hours of that person who has worked on the transaction.
Transaction.
I'm not talking of man days, I'm talking man hours. So if I have an employee who works on 4 transactions at a time, but he works 8 hours a day or 10 hours a day, and in each transaction, how much he has to prepare his log sheet accordingly. Big Fours have been charging this regularly. You can also have with this fee structure a success fee based fee.
Yes. That is not, it is not either or. You can have both.
You have to create your own combination in negotiation.
You have to have both.
You can say, okay, this lower fees you are giving as per the minimum standards, but then I will require success fee if I am able to resolve.
Yes.
You negotiate on that one. Everyone will be happy to give you more if they are getting more.
Yes.
They are crying because they feel they will not get and they have to spend on us. So you create an environment where they also feel happy. Okay, to mere ko mil raha hai to dena hai na. Then you will also earn, he will also earn. But that is your call, risk call, how much you want to take on which side. The point that today to discuss is in this component, basically they have issued 2 components, component of fee of IP in CRP and escrow. These are the 2 issues. In fees, fixed fee structure, I think we should not have any objection of fee structure. Should allow it, except if we want to say that it should not be compared with claim, but some other. Then some other means what? We have to then come to that conclusion. We cannot keep it कि नहीं तुम claim नहीं दूसरा करो दूसरा क्या आंसर करो तो होगा वरना क्लेम नहीं आएगा.
नहीं आंसर करोगे तो वैल्यू के बेस पे होगा, लेकिन वैल्यू के बेस पे करके कुछ कम
वैल्यू तो अभी बात करना है सर.
वैल्यू पे बहुत कम जाएगा. Suppose you have a claim of 1,000 crore rupees और वैल्यू तो 100 crore रुपया मिलेगा.
सर वो वैल्यू एक बिग डिस्कशन का टॉपिक है जो अभी
इसमें
छेड़ना है कि
परसेंटेज ऑफ वैल्यू पे भी फेयर वैल्यू का ऊपर हुआ तो कुछ परसेंटेज मिलेगा वैसे नहीं है
सर वो सबका क्राइटेरिया क्या फर्स्ट ऑफ ऑल माय पॉइंट इज ये 1.5 लाख 2 लाख जो भी डाला है वो कौन से बेसिस पे लिया है देयर हैज टू बी सम साइंटिफिक बेस उसने आगे भी जो वैल्यू के बेस पे किया है उसने एक 306 केसेस का स्ट्रेटा नाउ डजंट दैट सैंपल covers the whole part no so how that sample can be considered to give these things third on the fees that they have been proposing 2% 3%, 1%, 0.75, 0.5, and 0 with number of days. Now, what is the basis of 1%? Why 1%? Why not 0.5? Why not 5%? No basis. It's a random numbers, imaginary number that someone sitting on the chair has thought, okay, इसको एक ही देना है.
Number of days से जो compare किया है ना, all cases takes number of days, and that it should be start with say 300 days के अंदर हुआ ना तो 1% and then beyond it should have been reduced. अभी तो ये 16 below 180 days तो कोई अभी तक एक केस भी नहीं हुआ होगा.
इसलिए लॉलीपॉप है बोला ना. आपको परफॉर्मेंस लीक जो भी है वो कभी मिलना ही नहीं है. वो सिर्फ लॉलीपॉप पकड़ा दिया कि ये है मिनिमम एक्सेप्ट कर लो और परफॉर्मेंस का लॉलीपॉप.
330 days में 5% जो डाला है and above 330 days it is 0. तो उसमें कुछ तो डालना चाहिए था ना. Above 330 days is because of lot of litigation.
330 days पे 1 होना चाहिए फिर बात नहीं करना चाहिए. 330 days पे 1 होना चाहिए था फिर
बाकी सब नीचे होना चाहिए था.
उसमें 330 days में वो एक्सक्लूशन आएगा क्या आएगा which is to be considered कोई क्लैरिटी नहीं है.
सर इसमें ये चीज जुड़वाना चाहिए कि जो भी पीरियड एक्सक्लूड होता है दैट शुड बी एक्सक्लूडेड इन काउंटिंग दिस आल्सो.
हां तो वो तो ऑटोमेटिक हो गया ना. इफ दे आर एक्सक्लूडेड देन इट इज ऑटोमेटिकली एक्सक्लूडेड ना.
नहीं वो क्लियर है क्या ऑटोमेटिक
डेज काउंट पे एक्सक्लूड हो गया. ये दिखा नहीं है.
Very clear. 330 days include the period of litigation.
नहीं बट एक्सक्लूजन हो गया. जो कोविड एक्सक्लूजन हो गया समझो.
330 days में कंक्लूड करना है लिक्विडेशन लेके जाना हो रहा है नहीं हो रहा है फिर
क्या करें अभी वो तो
इंसेंटिव क्यों दे.
नहीं सर अपना इंसेंटिव का बात करो ना. वो लॉ छोड़ो.
अच्छा
इंसेंटिव का बात करो ना.
ज्यादा के लिए एग्री करता है तो कोई रिस्ट्रिक्शन नहीं.
हाँ
नहीं है कि नहीं है गारंटी मिनिमम नहीं है. ये तो इंडिकेटिव टेबल दिया है. इट इज नॉट मिनिमम. डोंट एक्सपेक्ट कि ये मिलेगा ही मिलेगा.
नहीं मिनिमम नहीं इंडिकेटिव है या फिर
दिस इज रीजनेबल फीस कंसीडर.
रीजनेबल फीस कंसीडर
नहीं ये इसके ऊपर कहाँ लिखा है.
24th पॉइंट पढ़िए. 24 it is proposal में it is proposed that the variable fee structure given in table 5 below be considered as reasonable for IP who has completed CRP on time.
These are the it is proposed a variable fee structure given be considered reasonable for the IP.
आप इससे ज्यादा चार्ज नहीं कर सकते हो.
आप ज्यादा नहीं कर सकते मतलब मिनिमम और मैक्सिमम दोनों यही कर रही है.
नहीं मिनिमम 1 लाख रुपया वाला जो चार्ट है वो मिनिमम मंथली फीस है. उसके ऊपर ये है
परसेंटेज वाला जो है ये
प्लस फिक्स प्लस दिस. तो अभी ये जो परसेंटेज वाला तुमको मिलेगा तो मतलब समझो अगर मेरा 1.5 लाख वाला है 10 करोड़ का क्लेम है और मेरे को 1.5 लाख रुपया मंथली मिल रहा है ठीक है प्लस परफॉर्मेंस का जो तो परफॉर्मेंस में मेरे को 1%
प्लस परफॉर्मेंस के लिए मिनिमम वर्ड नहीं है ना. दैट इज व्हाट आई एम सेइंग.
ये रीजनेबल है. वो मैक्सिमम दे दिया उसने मैक्सिमम ले लिया.
ये मैक्सिमम
रीजनेबल डाल दिया तो मैक्सिमम हो गया.
लेकिन वो मिनिमम तो नहीं भी बैंक बोलेगी नहीं देना है तो
देना ही नहीं है तो खत्म हो गया.
खत्म हो गई ना. यू डोंट हैव अधिकार नहीं है.
टेबल परसेंटेजेस जो आप पढ़ रहे हैं इसमें अगर नीचे आप पढ़ेंगे सब्जेक्ट इट सेज
मैक्सिमम 5 crore रुपए.
हाँ so that is realizable value they have kept to 5 crores
maximum.
हाँ so that means even if you consider 1% so what quantum are you looking at?
Total fees cannot exceed 5 crores.
5 crore.
The asterisk is at realizable value. So what exactly is it? The fee पे cap है या realizable value पे cap है?
Realizable amount पे fee पे cap है.
Realizable value तो maximization of value
है ना. उस पे cap नहीं है. मैंने समझो 5,000 करोड़ का भी एसेट रियलाइज किया तो मेरे को जो है वो मैक्सिमम इंसेंटिव 5 करोड़.
10 करोड़ नहीं मिलेगा 5 करोड़.
सर क्या है जुडिशरी ने 5-6 बार लिख के दे दिया IBPI को कि ये फी का कोई स्ट्रक्चर होना चाहिए. जुडिशरी को वो जज ओपन कोर्ट में बोलता है रेगुलरली कि IP को इतना फीस क्यों देना चाहिए. तो ये वो वाला चीज चल रहा है. वो वहां से वहां गया और अभी IP के फीस पे कैप आ First, when you are working for a large corporates, you are working for a small corporates, whatever is the size. Initially, it was left to market mechanism. Then why are you doing this chart? This chart should only be applicable where there is no fees recommended at any place. Like OC is appointing and there is no fees finalized, this chart should be applicable. It should not be applicable in all the matters. What they are doing by putting this thing, it will be made applicable to all the banks. Everyone will go by this chart only then. और अपने यहाँ एक कॉन्सेप्ट इंडिया में बहुत बेकार है कि वो मिनिमम बोलते हो ना तो उससे ज्यादा कोई देता ही नहीं फिर। आज सीए इंस्टीट्यूट ने मिनिमम रेकमेंडरी फीस रखा है, कितने चार्टर्ड वो मिनिमम का चार्ट फॉलो करते हैं? रेकमेंडरी है तो
नहीं कर सकते।
बट इसमें एक अच्छा है कि ये रेकमेंडरी नहीं है, ये मैंडेटरी है। इफ यू रीड दैट चार्ट, इट इज दैट दिस इज द मिनिमम फीस टू बी पेड। सो कंसोलेशन ऑन दिस इज दैट ये जो 1.5 लाख वाला चार्ट है वो अपने को उतना मिनिमम पैसा मिलेगा, उसके ऊपर क्या मिलेगा वो लॉटरी सबकी अपनी।
वो अभी निगोशिएट करो या जो भी है
एक्सपेक्ट करो कुछ मिलेगा नहीं। ये सर इसमें ये बताइए ये सीआईआरपी पे ही है कि और भी बाकी में भी?
अभी सीआरपी पे लिखा हुआ है।
सर एक जगह पे उसने मेंशन किया है कि अमाउंट विच हैज बीन पेड टू द मैनेजरियल पर्सन।
हाँ, टॉप मैनेजर मैनेजिंग डायरेक्टर पर्सन उससे कंपेयर होएगा,
उससे कंपेयर करो करके।
हाँ,
अगर वो टॉप मैनेजर पर्सन को 5 लाख पर मंथ देते होंगे तो क्या फिर अपना 1.5 भी लेके रहेगा?
वो बोला कि हमने ये सब देखा
उसके बाद में
ये सब हमने इवेल्युएट किया, हमने यूएस में ये होता है, यूके में ये होता है, वो सब का कंपैरिजन देखा, हमने ये 5 इंस्टीट्यूट का देखा और फिर हम ये प्रपोजिंग दिस। इसमें सेकंड जो फी वेरिएशन विद वैल्यू मैक्सिमाइजेशन उनका जो दिया है वो दोनों प्रपोजिशन फी के जो दिए हैं, वो दोनों प्रपोजिशन में मेरा कितना कॉल क्लेम अगर आया ही नहीं किसी का, लाइक ये बोल रहा था अभी राकेश बोल रहा था कि उसके पास वो क्लेम का इश्यू है, क्लेम आया ही नहीं किसी का, बड़ा क्लेम था आया ही नहीं, मैंने तो वो सोच के लिया कि मेरे को परफॉर्मेंस आएगा, अटक गया मैं। सेकंड वैल्यू, when you are talking about the value maximization, where is my role? It is a valuer's role. Valuer is determining the value and RA and COC is determining the maximization part. Right? Neither I have a role in maximization, neither I have a role in fixing the value, realizable value. How can my fees be related to that?
Value का
same logic applies even for 330 days also, no?
330 डेज में तो कहीं मैं हूँ ना, एक बार मैं छोड़ दूं, ये दोनों में मैं कहीं नहीं हूँ। 330 डेज में मेरे को टाइमलाइन मैं एक्सक्लूड कर दिया तो मेरा ही है ना, मेरे को तो 330 डेज में कंप्लीट करना है, वो तो आज भी मेरे पे।
और वैल्यू मैक्सिमाइजेशन का इंसेंटिव था ना, वो कहाँ है? वैल्यू मैक्सिमाइजेशन का इंसेंटिव था ना,
है ना, फेयर वैल्यू का 1% था ना, फेयर वैल्यू से जितना ऊपर है उसका 1% मिलेगा, ऐसा कुछ था ना।
पेज 11 पेज 10 Schedule 2 आप देख रहे हैं और
Yeah.
Second last page, below the table. That table itself is for value, right?
175 वाला।
सर देयर इज अ न्यूज़ की ये जो इंडिविजुअल्स
ये तो टाइम का है ना,
कर रहे हैं और कंपनीज को देना शुरू कर रहे हैं, एंड देयर इज अ डिस्कशन पेपर ऑन
टाइमली कंप्लीशन का ये
आने वाला है 2-4 दिन में।
आईपी फॉर्म को काम देंगे,
आईपी फॉर्म नहीं मतलब
आने तो दीजिए सर,
देंगे और इंडिविजुअल्स को नहीं देंगे, इसका डिस्कशन पेपर आ रहा है।
मिंट में है, कंपनीज नॉट इंडिविजुअल्स टू रन बैंकरप्ट बिजनेस।
मिंट में है,
मिंट में है।
पूरा कंसेप्ट ही अलग हो जाएगा ना। The very objective of having an individual is to fix a liability. Corporate में कहाँ पे liability है?
और कॉर्पोरेट में रहेगी liability, उसके जो पार्टनर्स रहेंगे उनकी रहेगी, या डायरेक्टर्स रहेंगे उनकी रहेगी।
करो
फीस का
सबको करो सर, एवरी केस के लिए सबको रिस्पॉन्सिबल करो, मैं तो अभी बोलता हूँ करो।
नहीं अपने को नहीं रखेंगे।
Proposal will be released for public comments by the Insolvency and Bankruptcy Board of India in a fortnight.
ना फोर्टनाइट में आ रहा है ये।
आने तो दो पेपर को सर, आने तो दो, देखो क्या है
सर। नेक्स्ट मीटिंग इसके ऊपर ही रहेगा।
अच्छा पहले फीस के ऊपर डिस्कस करते हैं।
ये जो चार्ट है
पहले फीस के ऊपर डिस्कस करते हैं सर।
ये रियलाइजेबल वैल्यू
सर व्हाट इज योर ओपिनियन
और
ऑन
ये
दिस?
डेज के साथ ये दोनों का मिला के ये क्या मतलब?
वो तो
सर व्हाट इज योर ओपिनियन ऑन दिस
फेयर
चार्ट,
वैल्यू से लिंक नहीं किया
ऑन दिस डिस्कशन पेपर?
एक्चुअल
फेयर
रियलाइजेबल
वैल्यू से ज्यादा कितना है वो एक था
वो ये नहीं, ये वाला जो था वो तो नंबर ऑफ केसेस का
इट्स अ वेलकम बिगिनिंग एंड
वो
फॉर
सैंपल है, सैंपल है, फिर इससे ये निकाला है डिराइव किया।
इंसेंटिव इन्होंने फॉर टाइमली कंप्लीशन और फॉर
ये दोनों का कॉम्बिनेशन का चार्ट है,
एक ही चार्ट है।
एक ही चार्ट है।
It should be on total claims, not claims accepted. At least उतना तो वो कर सकते हैं। हम लोग रिजेक्ट कर दे। तुम मर गए। हुआ है, मेरे साथ भी हुआ है। नो क्लेम, I approach NCLT. I approach NCLT.
1.5 lakh.
No claim, no COC form.
1.5 lakh.
1.5 lakh तो है यार। तो start with 1.5 lakh तो है।
1.5 lakh.
आई थिंक इसके लिए एक अलग शाम को मीटिंग रख देते वापस।
मैडम व्हाट इज योर ओपिनियन ऑन दिस?
This one limit minimum they have given to my COC में if you want to increase the fees then they will have that bargaining point की एक minimum के आसपास. You cannot escalate much. They may have that put a threshold and they will not.
Any other points on this percentages etc?
It's a minimum. So
महेश जी व्हाट इज योर ओपिनियन?
ये पूछे ना तो 1000 करोड़ पे जो फीस दिखी ना 3 लाख रुपया बहुत कम है।
कम है
बहुत कम है। 1000 करोड़ पे जो 3 लाख रुपया जो लिखी है ना, क्योंकि एक दो आदमी रखोगे तो वही 1.5 लाख रुपया लेके जाएगा। तो 2 आदमी रखे 1.5 लाख रुपया लेके गया तो इधर 3 लाख रुपया ऑफिस ओवर है तुम्हारा।
कुछ उनको सजेस्ट करना चाहिए IPA की तरफ।
सर वही क्या
बोल रहे हैं ना, ऐसा कुछ रिवाइव सजेस्ट करना चाहिए अपने को।
तो क्या बोलो, एक दिन शाम को अपन सब मिलके डिसाइड कर लेते हैं ना वापस।
कर सकते हैं
एक दिन शाम को अगर आके यही हॉल में बैठ के अपन डिसाइड कर देते हैं।
Online if anyone has any views please unmute yourself and open your video and we would like to hear your views.
अभी कोई बचा है क्या हॉल में?
Asset side of the balance sheet or liability side of the balance sheet.
Online is anyone available sir?
You link it with that. Can you link that?
राकेश जी आपका क्या ओपिनियन है सर्कुलर के बारे में? अच्छा सर्कुलर है क्या? सर्कुलर आपका क्या?
Whichever is higher, claims admitted or liabilities as per the
Liabilities are always much higher. Don't go by the assets.
Madam, what is your view?
Both higher.
Madam,
तो जितना ज्यादा
liability का interest rate होता है।
Going higher is welcome, but the upper limit, as you say, you all say, be dependent on the realization. There should not be much of a cap on that.
so what is your view?
whatever amount is mentioned there, it is always subject to negotiation. So either you increase or decrease.
Decrease?
Decrease
is a minimum,
but minimum amount is not, threshold limit is not a fixed limit.
See, it is not a. It is a minimum. So below that one should not accept. That is clear.
Now, at present,
But bank will not give more than this. That is another side.
At present, banks are maintaining their panels for valuers and advocates. There are also these slabs are there, but they are not paying as per slabs. There is always negotiation. They are charging 50% of the table value. This is the practice followed by the bank. We are already on the panel of the banks for valuation purpose. So there are also fees are prescribed, but they are not giving the same fees.
Sir, let's come to a point. ये सर्कुलर में क्या बोलना है? आपको सबको कमेंट्स डालनी है जाके IBBA के साइट पे, बराबर है? तो क्या डालनी है? What you want to pass a specific comment, then what? And if you want to pass a general comment, then what? I will just read out the options. So submission of comments may be submitted electronically by 30th of June. Visit IBBI site, select public comment, select discussion paper remuneration of IP, provide your name, email ID, select the stakeholder. So all of us has to select insolvency professional. Then select the kinds of comment, general comment or specific. If you select a general comment, then you have to select one of the following: inconsistency with provision of regulation, inconsistency with provision of different regulation, inconsistency between the provision of regulation with those of rules, inconsistency between provisions of regulation with those of code, inconsistency between provisions of regulation with other laws. Any difficulty in implementation of any of the provisions of regulation. Any provision that should have been provided in the regulation has not been provided. Any provision that should have been provided in the regulation but should not have been provided. Any provision should have been provided in regulation has not been provided. That is one from this general comment.
We can have our views. Then how to frame in our views when we are putting our comments, we can definitely choose in how and where we want to put those views. But at least we can start having our views. So at least on that we can discuss.
Second is specific comments. In specific comments, it is to select a para or regulation number and then sub-para, sub-regulation number and write comments against selected para, sub-para. So you have to be very specific when you are giving specific comments. So nothing hypothetical, you have to relate it with the code and then this is the format in which the suggestions are invited.
This is general format for any suggestion. Now why this format has been kept is, today I am having a case. When I am having a case, I am having a particular clause, which I find and see in general reading we don't find that. When we wear the shoe, we know where it pinches. At that point of time, I faced a situation I want to comment. So for this very specific has been comment. That I faced the situation under this regulation, under this code, this is a situation which I am facing. This is the problem. Because this is an ever-growing law, it's a new law and ever-growing law. That is why this format has been kept. Once we give this in that particular format, it is a very receptive regulator. They will immediately look into that. And that is how the changes are coming. So this is a general format for any suggestions.
My suggestion is there should be a revision in fees based on the circumstances. This is a minimum fees now.
Maximum you can negotiate.
We can have one special discussion on any evening, say 6:30 to 7:38 on this paper, because today I think now time is over and everybody, I myself was to rush and most of them have left also.
If you could all give certain basic guidelines regarding the specific comments, it would be useful because the hardly time now. So 30th June we have to make a comment.
Today is 11th, no, so in the next week if we meet for say 1.5 hour, we come prepared, we do our homework and come, then we can combine everything.
In the group and then we can discuss later.
First of all, madam, that is my opinion. Whenever I want to give a suggestion, of course, it's first of all, this is a very welcome discussion paper from the regulators. This was much awaited and long due. This is a step in right direction, first I would say. Second, maybe we have learned what are the views of our peers over here. Some would be seniors and some fellow professionals. After hearing our views, we can independently read the paper. We can apply it in the circumstances we have been through or we expect the circumstances to be. And we can just put a thought that how ideally we should think it should be better. Simply maybe someone suggesting me or I suggesting someone, it is better I put it as...
But just the guideline, right? The capping or whatever.
Yeah, we can, maybe on that we have had enough discussion. Whether you think minimum is enough or the percentage fees etc. should be there or the percentage fees, how it should be calculated. Maybe the paper is very clear on what aspects it is touching. If you are comfortable with those aspects, put those aspects. If you are uncomfortable with certain points or have a different opinion, opine on that with why and what. And finally, that would be compiled and given thought of.
This wording what Snail Bhai said now, that provide the fees as cost charged by we must be transparent and reasonable reflection of the work necessary and properly undertaken. Now, what is reasonable reflection of the work? That is not defined. I am facing a case where the CRP was dragged for 1 year in the COVID period, and now they are saying there was no work performed.
Correct.
And but then my staff, my cost, my office overhead was all running.
Everything was running.
So can I tell to my staff that because I have not got the fees, I will not pay?
I will not pay. This is not.
I have already paid.
Snail Bhai is ready answer for that.
See, the IP.
bolo na.
The simple है. I have also faced the same situation.
Yes.
Most of us would have faced the same situation for COVID period.
Yes.
Okay. We had taken a stand that in that period, had there been a loss of asset, who would have been responsible?
Me.
Me.
Yes.
So I have guarded your asset, you pay me. NCLT said that. NCLT has said in one of our case, we had fought tooth and nail with COC on that. Where COC said that काम ही नहीं किया है. बोला सर उसका फ्री में मेरा सिक्योरिटी गार्ड खड़ा था, मेरे को पहले ही बोलते थे नहीं देता था, गार्ड को मैं हटा देता था. जाने तो उसका माल मेरा क्या जाता है. I told in the open court that we have guarded his asset for which we are appointed. We are not supposed to do any other work. During COVID, government guidelines did not allow me to do any work. That doesn't mean I have not done the work. During
His
the
salary was paid.
closure, I have done
If he
this.
has not worked ARC, his salary is paid.
I have taken, in my all case, I have fought and taken. Only in one case, my fees is stuck since last 2 years. But that is one case. Other than all that, we have gone and we have to fight it out.
तो फाइटिंग करते हैं उसमें.
वो COC बोलता है मैं तुमको केस नहीं दूंगा, मत देना बोला. तू अकेला बैठा है क्या मार्केट में काम देने के लिए मेरे को?
बस काम होता है.
नहीं आएगा तेरे पास. बट वो फिर बोलने का ताकत होना चाहिए. वहां सब डर जाते हैं ना तो काम फिर छोड़ देते हैं. हाँ चल चल ठीक दे देख जो दे रहे. वो बैगिंग बॉल्स लेके बैठा हो गया फिर कुछ नहीं होना है.
One aspect which we should not accept is that COC may also decide fee of an IP for the period from the submission of COC approved resolution plan to AA till approval of the resolution plan.
But now banks have started now saying you give the quote in two things, two stage. One till the approval of the plan, means till the submission of the plan. Second, post submission of plan till the final order. So, and in that also include that if the 12 withdrawal is filed, then what will be the fees? If this.
Sir, this circular says specifically that the fees which are prescribed in this table are only till the time the resolution plan is approved by COC. But that's all.
That's all.
उसके बाद
If you want to have any additional, if RP want to charge any additional fees,
Additional नहीं, additional नहीं, वो discount हो जाता है.
अब तो जो होगा है वो बात अलग है, लेकिन कहने का मतलब क्या है? As an RP, you should have negotiation power कि भाई तब तक मैं सब सिक्योरिटी गार्ड ले लूँ क्या? जब तक आपका ये है, तब तक मैं सब पूरा ये करूँगा क्या? नहीं
ये तो आपकी ड्यूटी है.
हाँ नहीं जब तक मैं पूरा अपना काम बंद कर दूं क्या? आपको you have to bargain with them.
नहीं बट लेकिन
can't say कि भाई वो रेगुलेशन में लिखा है तो ठीक है मत देना करके, तो ठीक है मत देना तो मत देना.
मत देना की बात नहीं है. ये से 30% डिस्काउंट, 40% डिस्काउंट पोस्ट सबमिशन ऑफ द रेजोल्यूशन प्लान.
वो बोलते हैं
तो आपको आर्गुमेंट करनी है. अगर आप उसके साथ जीत जाते हैं तो ठीक है. वो बोलते कौन से बेसिस पे आप बोल रहे हो 30-40%, आपको जस्टिफाई करना है आपका. It's upon I think वो होता ही है.
रनिंग कंपनी में सब पैसा
मिलता है.
बंद कंपनी में
ही रोना है भाई. बंद कंपनी में ही रोना
है. तो आप अपने आप को उसकी जगह पे रख के देखिए कि भाई रियली आरपी इज वर्किंग ऑन दैट ग्राउंड और नॉट, और वेदर हिज फीस इज जस्टिफाइड ऑन दैट ग्राउंड. आप अपने आप को उसके शूज में एंटर करके देखिए ना, आपको आपका जॉब मिल जाएगा.
और कम करने की बात करते हो.
यू विल गेट योर आंसर.
सर एक तो फीस आप 1 करोड़ दो, 1 लाख रुपए भी नहीं देते हो, और उसमें भी बोलते हो कम कर दो, तो फिर क्या करें?
अहमदाबाद में तो 50,000 से ही चालू होता है.
अच्छा.
Okay, thank you friend, thank you very much for your
participation. And I sincerely request to come up and take the lead on any of subject of your interest.
Excel कराटा.
Yes, चलेगा. सर एक दिया था. फिर क्या? कोई नेक्स्ट में वेलकम.
रुक लेटा.
फीस पे
तो अपने को 1 महीना नहीं, अपने को शाम को जल्दी नेक्स्ट सैटरडे रखना पड़ेगा.
कर लेते हैं.
नेक्स्ट सैटरडे वो नीचे पूरी चालू हो रहा है ना डायरेक्ट टैक्स रिफ्रेशर कोर्स, तो पब्लिक उसमें भी चली जाएगी काफी.
कोई नहीं करता सर आजकल, सब रिफ्रेश है. विल टैक्स में आप कुछ बचा ही नहीं है.
फिजिकल लेवल में लोग भी इंटरेस्टेड है तो उसका
बचा है.
ये अपनी नॉलेज है. हाँ
थैंक्स देवांग भाई.
क्या देवांग भाई, यही एक तरह से